All right. Thank you so much, everyone, for coming today. My name is Will Hanlon, and I'm a second-year law student here at Osgoode. And this year, I've been lucky to be a member of the Environmental Justice and Sustainability Clinic. And on behalf of the clinic, I want to welcome you all to our Student Research Symposium, What's Actually Happening in the Ring of Fire. Before we get started, I want to acknowledge our presence on the traditional territory of many Indigenous nations. The area known as Tuckeronto has been caretaken by the Anishinaabe Nation, the Haudenosaunee Confederacy, and the Huron-Wendat. It is now home to many First Nation, Inuit, and Métis communities. We acknowledge the current treaty holders, the Mississaugas of the Credit First Nation. This territory is subject to the Dish with One Spoon Wampum Belt Covenant, an agreement to peaceably share and care for the Great Lakes region. In today's symposium, we will try to make sense of the rapidly changing regulatory landscape across the Indigenous homelands of Treaty 9 in Northern Ontario. We will consider the environmental and impact assessments for the Ring of Fire roads, the ongoing regional assessments, the likelihood and possible consequences of designations in the Ring of Fire as a special economic zone or a project in the national interest, and the wide sweeping impacts on both Indigenous self-determination and democratic rights of the onslaught of fast-tracking legislation. We are so lucky today to be joined by representatives from Neskantaga First Nation, youth land defenders from Attawapiskat First Nation, and the co-founder, and they're just walking in, and the co-founder of 8th Fire Rising, all of whom will participate in a Q&A session later today. Without further ado, I'm going to turn things over to Allan Moonias, a councillor with Neskantaga First Nation, for welcoming remarks. Thank you.
Good morning. My name is Allan Moonias. I'm from Neskantaga First Nation, and we live in the Attawapiskat River, where the Ring of Fire is being proposed to cross. Today, some of our members are here to join and to listen in. And we appreciate for getting the invite and to be here and to listen in today. Okay, thank you very much. I got you.
Okay, thank you very much, Councillor Moonias, and thanks to all of you for being here. It's really great to see so many of my students and former students, and of course my collaborators in Neskantaga First Nation and our guests from other parts of Treaty 9. My name's Dayna Scott. I am a professor here at the law school and cross-appointed to the Faculty of Environmental and Urban Change at York University. I'm also the director of Osgoode's Environmental Justice and Sustainability Clinic, and that is the place where we do really awesome community engaged research, and you're going to hear from many of the students in that program here today who've been doing work this year that I'm very proud of. So thanks for joining us. I want to acknowledge that, the state of the world today, this morning, and over the past few days is pretty difficult. And the interesting thing that we may want to consider today is the connection between the violence that is ongoing and the extraction of minerals, including critical minerals from the north of Ontario. And in particular, we have been, many of us, for the past few days downtown at what we call the PDAC, the Prospectors and Developers Association of Canada's annual meetings held in Toronto, which is really sort of the epicenter of global mining. And Down there you hear a lot of talk and excitement about the demand for minerals that is accelerated by war, basically. And so this is, I think, something for us to consider as we go through our day. And so again, I want to acknowledge the leadership here from Neskantaga First Nation, the membership, my longtime collaborators, my new friends from Attawapiskat First Nation, and hopefully this afternoon you'll also meet Eve Saint, who's the co-founder of 8th Fire Rising, as part of our Land Defender panel. So I wanted to start this morning by just giving like a very basic intro to what is and where is the so-called Ring of Fire for anyone in our audience today that is not familiar with it. So I want to start by saying, if you saw this, you probably also saw a lot of this, and that is the ads that Ontario was running during the World Series this past fall. And in those ads, you would have heard that the Ring of Fire holds massive amounts of minerals needed for things like electric vehicle batteries. Ontario also said that mining in the region would add $22 billion to Ontario's economy over 3 decades. And during the World Series, these specific ads took up more time than any other spots, aside from Rogers itself, and could have cost up to $150,000 per spot. So Ontario was really trying to sell us on something, right? And that is a connection between the kind of extraction they say we need to do in the northern homelands of Treaty 9 and the kind of economy we want to have here in southern Ontario. So the Ring of Fire, that term, is actually a name given by prospectors to a mineral deposit, an area of mineralization, as they say, that had a crescent shape back in 2017. If you look at a map like this today, and of course we're talking here, you can't even see Thunder Bay on this map. So this is the part of Ontario that is usually not even included in maps of Ontario that we look at. Many of those end at Thunder Bay. This is the part of Ontario, vast peatlands that exist north of that, of the highways, basically. So at the bottom of this map, you'll see the end of the provincial highway network. If you look and see this green speckled part through, that's the Hudson Bay lowlands. Those are the peatlands. So you can see how much water is on this landscape, and we'll hear a little bit more about that later. Okay, so I was just talking, I think, about the peatlands. So yeah, if you were to look at this map again today, and it showed the extent of mineral exploration and the staking that's gone on throughout that part of Ontario, that crescent shape would be completely filled in. It's just like a big blob now. And there's been a massive exploration rush over the past 5 years or so, but really extensively in the past 2 or so. That staking, of course, is done under a free entry system in Ontario, which means that mining companies, when they go to do exploration, immediately upon staking a claim, which is done electronically, they gain some rights to the land and to the eventual extraction of the minerals and ownership of the minerals that come from that territory. In reality, the quote-unquote Ring of Fire is actually in the homelands of various Indigenous nations and has been since time immemorial. This is an area that's been occupied and caretaken by Anishinaabe, Oji-Cree, and Cree peoples across this territory. Many of the communities that are in the closest proximity to the quote-unquote Ring of Fire mineral deposits are roadless fly-in communities, remote communities that are, as you'll hear more today, of course, very rich in Indigenous culture and language, land-based practices, living from the land and the river systems, but are also denied basic community infrastructure by the settler state, like safe and clean drinking water, adequate housing, healthcare services, etc. Neskantaga, as you will probably know, has endured the longest running boil water advisory in Canada, now at over 31 years. So the two communities we have represented here today span the length of the Attawapiskat River, and they've been setting up camp in order to defend those homelands, which we'll hear more about later today too. And these are some of the images of that continuing work and the efforts they take to fulfill their obligations under their own laws, including in Neskantaga stewardship program to protect the lake sturgeon. So for a while, you will know, Ontario from about 2022 to 2024 pitched access to these minerals as critical to the green energy transition. Ford talked a lot about unifying the supply chain all the way from extraction to the production of batteries to the production of electric vehicles in southern Ontario. Now, in the wake of President Trump's tariff war and threats to annex Canada, and in its demand for patriotism in the name of economic emergency, that climate pretext for this extraction is almost completely dropped. The minerals are admitted to be just critical for economic domination, warmongering, weapons, and security for some. But the need to dispossess Indigenous peoples of the region of their lands and governing authority remains for the extractive project to continue. And roads have been the crucial infrastructural linchpin to that plan. So many of you will have heard about and will have seen again at PDAC this year plans to get these roads fast-tracked. There have been bilateral deals with some of the remote First Nations who have become, quote, proponents for the purposes of environmental assessment. These roads are going to be expensive. They're going to take an extremely long time to build. But they are what the mining industry is waiting for in order to really spend any money on investing in actual mining projects in the Ring of Fire. So the last thing I'll mention, just as an update before I turn it over to the students, the clinic drafted on Neskantaga's behalf over the past year or so a formal designation request to the Minister of Environment and Climate Change Canada to designate the Eagle's Nest mine, which is the most advanced project, a nickel mine, a proposed nickel mine, just past the crossing of the Attawapiskat River, for environmental assessment, federal environmental assessment. And this was necessary because Ontario had already passed a law as part of Bill 5 last spring, which exempted the Eagle's Nest specifically from provincial environmental assessment. The proposed project in terms of the volume of nickel to be extracted falls below the threshold that would automatically trigger the Federal Impact Assessment Act. And so we made the request that they designate it for impact assessment. That request was denied about a week ago, and the reasons given from the president of the Impact Assessment Agency were that essentially there were already legislative measures and other instruments in place that could address the adverse effects on areas of federal jurisdiction. So the minister admits that yes, there will be adverse effects on Indigenous people's rights under Section 35. Yes, there will be adverse effects on fisheries, on migratory birds, on species at risk, on peatlands and climate, etc. But says that we have adequate legislative measures in place to address those adverse effects. And then points to a number of laws that do exist in Canada and Ontario, but that are also subject to being waived through the kinds of legislative measures that you'll hear a little bit more about today. So in closing, just back to the Here We Stand camp, looking forward to this afternoon's panel that shows the way that despite all of these failures of the settler regulatory system and settler law, Anishinaabe law and other Indigenous law applies throughout Treaty Number 9 and continues to govern there. And I think that's where we'll hopefully end the day. So I'm going to pass it over now to James, who can introduce himself and start talking about the research.
Hi, everyone. Can you all hear me okay? Great. So my name is James, as Dayna said. I'm a second-year law student and also a member of the Environmental Justice and Sustainability Clinic. I'm here to talk to you today about the research I've been working on for the past few months. And it's a down arrow? Okay. There we go. So I'll be talking to you today about how we're actually going to get to the Ring of Fire. So just a brief overview of what I'll be talking about in my presentation. I'm going to give you a brief overview of the current road projects into the Ring of Fire. Then I'm going to talk about some of the other proposals that have been advanced and then discarded over the years. And I'm going to talk about how these proposals may be coming back in some way in the not-so-distant future as the Ring of Fire continues to develop. So as Dayna noted earlier, the Ring of Fire is over 300 kilometers from the nearest paved road. And so the biggest concern for any proponent of development in the Ring of Fire is going to be getting there. You need some kind of ground transportation to get minerals out of the Ring of Fire. Helicopter mining is not an option. And so the current hopes of Ontario and mining companies are staked on a road project. So the current trio of road projects that are currently underway in the Ring of Fire are the Webakwe Supply Road, which you're going to see up in the top left over there. It's that kind of L-shaped line jutting down. Then on the bottom, you have the Martin Falls Community Access Road. So you see the Martin Falls First Nation symbol down there, and that comes up. And then in between them, that colorful sort of forked line is the Northern Road Link. And the Northern Road Link is intended to link these two projects together and basically create a connection between the provincial highway network and the Ring of Fire. You'll see there's a bit of a fork in the middle of the road there, and that's because developers of the Northern Road Link have not quite figured out where they want to cross the Attawapiskat River yet. So with regards to where these projects are currently at, all of them are very far along in the permitting process. Ontario announced this past Monday that the Webakwe Supply Road is due to begin construction in June of this year, and they're estimating it to be finished around 2030. The Martin Falls Community Access Road is going to begin construction in August of this year, and it should be completed construction in 2031, around November. And the Northern Road Link, they're hoping to begin construction in the spring of 2028, and they're hoping to have it finished alongside the Martin Falls Road in November of 2031. So quite far along. There are still some logistical questions that need to be answered about the roads themselves. The majority of the Northern Road Link is going to be built along the eskers in the Ring of Fire. These are large gravel ridges that are some of the only solid ground in the region. But some parts of the roads are going to need to cross peatlands, essentially, a bog, a swamp. It's not stable ground. And we're going to hear more about the eskers in the Ring of Fire and also about the need for it to cross the Attawapiskat later today. So I'm not going to try and step on anyone's toes here. But just for the sake of my research, the Northern Road Link was the ideal starting point because it is the road project in the Ring of Fire out of all the various proposals that have been floated, right? Development in the region has been considered for almost 2 decades now. And there's been a number of different proposals about how to get there. And so what I wanted to do was look at the history of these proposals. And what I found interesting particularly was, despite all the kind of commotion around the Northern Road Link, these other proposal ideas for accessing the Ring of Fire kept getting floated. Things like a railroad or a different road, one that didn't run from north to south, but rather from east to west into the Ring of Fire. And so this is what I looked into, and I looked at the history of these proposals, and I looked at how they are being kind of speculated about being brought back once the Northern Road Link is done. So to get into a kind of more detailed overview of some of the relevant proposals for getting into the Ring of Fire, basically, there's been a few. So to start out, I just want to say the Northern Road Link, where this fits in the research, is this is the end point. The Northern Road Link is the north-south road that beat out all the other proposals due to a couple of advantages it has that I'll talk about later. But the first major proposal for the Ring of Fire actually came from Cliffs Mining. This is a mining company that owned the Eagle's Nest mine that Dayna spoke about earlier. Before being bought, they sold their shares in it to Wailu later on. Wailu is the current owner of the Eagle's Nest mine. And Cliffs also owns several major chromite deposits in the region. So Cliffs basically examined both the north-south road. It's kind of hard to see, but it's that yellow dotted line, green dotted line running up into that crescent shape up there. That's the Ring of Fire. And they also looked at an east-west road. It's a lot harder to see, but it's that kind of dotted red line that passes up there also into the crescent shape. And Cliffs basically said that the north-south road would be the most viable route into the Ring of Fire for a couple of reasons. First, it was, even though it is expensive, it's the cheapest out of all the proposals to build. And in addition to that, it supported the construction of a north-south railway later on, which would make mining in the Ring of Fire a lot more viable. They were extremely dismissive of the east-west road. They said that if it were built, it would basically kill the Ring of Fire as a kind of development project because it would just stifle any further infrastructure development in the region. In 2013, KWG, which is another mining company, has also performed a feasibility study on various transportation options into the Ring of Fire. They looked at this similar east-west road here, as well as a railway, which is the yellow dotted line leading from down there near Nakina up to the Ring of Fire. And KWG was very much in favor of the railway. They said that it made chromite mining cheap enough to actually be profitable. And they also said that it would be way more environmentally friendly than a road. And they noted that if any local First Nations in the region wanted a road built, that a railway would help to preserve the road much longer and essentially not beat it up as much since there wouldn't be 80-ton trucks driving over it every day. The main downside of a railroad into the Ring of Fire is that not only would it be difficult to build, but it would be insanely expensive. Railway has the highest startup cost of any of the transportation proposals into the Ring of Fire. And so for this reason, Ontario would not even budge. So an important thing to keep in mind when I'm talking about the history of these proposals is mining companies are very, how would you say, they want to have their cake and eat it too. They want the project to be built that is going to best service their mining prospects, but at the same time, they don't want to pay for any of it because mining is an extremely unprofitable, high-risk venture at the start, and until the mine is up and running for a few years, there's no money to be made. So they want the government to pay for all of it, and they're willing to go along with whatever the government says. If the government won't play ball, then they're happy to just sit on their hands and do nothing with their claims, and that's exactly what KWG did. Also in 2013, Wailu, then known as Noront, also did a kind of environmental assessment and feasibility study of roads into the Ring of Fire, and Wailu actually favored the east-west road. And there are a couple of reasons for this. First, the east-west road would be built alongside the existing ice roads in the region, and so it would be less disruptive to the environment. It would also service more First Nations. It's 4 as opposed to, I think, the north-south road that Wailu examined serviced no First Nations. And they also noted it wouldn't damage any of the eskers in the region. And this is important because many of the eskers contain important cultural sites and burial grounds for local First Nations. And so I think the basic thought here for Wailu's support of this route was that Wailu wanted the road built, and they wanted it built quickly, and they thought that local First Nations would be more likely to support this option. And in addition, Wailu didn't really care about which way the road ran. They just wanted a road, because for the specific kind of mining that's being done at Eagle's Nest, they are looking at mining nickel, not chromite, as the other Ring of Fire proponents were. And nickel concentrate is a lot lighter than chromite on average, and it's a lot easier to ship out via a truck. Whereas for chromite, it's so heavy that really a railroad is the only economically viable option. So to make a long story very short, Wailu said a railroad is unnecessary, it's not needed to start the mine, and it would not be helpful for local First Nations in the way a road was. So they went with the east-west road. But remember, as I said, that mining companies are very, very mercenary. And so what ultimately happened is Ontario, just due to the ease of negotiation, decided to go with a north-south road. And Wailu saw that and said, great, we want a north-south road. And so the east-west road proposal was set aside. And since then, a north-south road has been the main contemplated route into the Ring of Fire. However, this has not been the end of either the railroad proposals nor the east-west road proposals for the Ring of Fire. So, like I said before, mining companies are very happy to just sit on their hands and sit on their claims to the land if the government is not willing to play ball with them. And that's exactly what KWG has done ever since. In a recent letter, I think it was December of this past year, to Webequie First Nation, KWG and Ontario asked them to look at the possibility of including a heavy haul railroad into their environmental assessment for the Webequie Supply Road. Webequie did examine this on their behalf, and they looked at it as an alternative to building the Webequie Supply Road. And Webequie ultimately rejected railroad as a starting point for construction into the Ring of Fire for many of the same reasons that Ontario did. It's insanely expensive, and it's insanely difficult to build. But this has not stopped KWG. They've been pushing for a railroad to be built in the Ring of Fire in various forms of media and other channels since 2013. And they've been very content to keep it on the table. You'll see this blue dotted line there. That is all of the land claims that KWG bought up in 2013 with the express purpose of creating what they call a north-south utility corridor, basically a railroad. And they're still pushing for the development of this. With regards to where railroad is going to come in the overall development of the Ring of Fire, right now, I think what's going to happen is the north-south road needs to be built first. And once they have this, it becomes a lot cheaper to build a railroad alongside it. But it's unnecessary to do this because only the Eagle's Nest mine is going to be up and running. However, once the Northern Road Link and the other road projects are completed and the Eagle's Nest mine has been up and running for a few years, I suspect the chromite mining companies like the KWGs and the Cliffs of the world are going to come back. And at that point in time, maybe somewhere in the 2030s, a railroad will need to be built because it's the only way to make chromite mining economically viable. Now, the east-west road, like I said, has also still been kind of on the table, but it's been talked about a lot more frequently. There's been 3 recent mentions of an east-west road in various kind of government sources over the past few months. So first of all, Ontario gave Webequie about $3 million in funding to look at the possibility of an east-west road in their environmental assessment as a secondary route into the Ring of Fire. In addition to that, the federal government funded Neskantaga First Nation to do a corridor study, which is explicitly looking at building an east-west road for the purposes of servicing Neskantaga, both with infrastructure and with an all-season road. And then finally, this is most interesting, Ontario has launched an east-west pipeline feasibility study with Alberta and Saskatchewan. And the feasibility study is ostensibly for a pipeline, but in the announcement about the study, they said they're going to consider complementary development opportunities. And if you look at the list of what is considered complementary development opportunities, roads into the Ring of Fire are first and foremost among those. So what's going to actually happen with the east-west road? I'm not too sure. To make a long story short, it's going to be a secondary possibility only because a north-south road is more economically viable. It supports the building of a railroad in the future. And the east-west road requires a lot more negotiation with First Nations, which is probably a good thing, but from a development perspective, it slows things down and has additional costs. Why would an east-west road be built? It's just another access point into the region. And so I think that it will definitely come later, but I think it will be coming, and a lot sooner than potentially a north-south railroad, just because companies want an additional access point into the Ring of Fire. So with regards to conclusions, about kind of infrastructure projects in the Ring of Fire. The Northern Road Link is, what Ontario wants to get built. They are, pushing this through with all available haste, 5 years ahead of current schedule. And so this is going to be the main thing to worry about for now. With regards to future developments, both the east-west road and the north-south railway were too economically unviable at the start to construct, but they will likely be coming at some point in the future. The east-west road seems very likely to come, just as a secondary kind of road to open up more ways to get into the Ring of Fire. The north-south railway will come later, once mining has been established in the region, because only a railway offers the economies of scale necessary to make mining of chromite profitable in the Ring of Fire. With regards to where to look to see when an east-west road might be coming, I think it's important to pay attention to the completion of Ontario's pipeline feasibility study, which is due in October of 2026. The study will contain a route for the proposed pipeline, as well as any evaluation of complementary development opportunities that Ontario will have done. And in addition to that, the Neskantaga corridor study I mentioned is only a very early preliminary study, but there may be some discussion of a route or a timeline in that study, and so it's worth paying attention to that as well. That's all I have to say to you guys today. Thank you for your attention, and I hope you learned something. So I'm just going to turn it over to Skye now.
Thank you, James. Hi, everyone. My name is Skye Baylis. I've been conducting research into the Ring of Fire, burial sites, and Aboriginal archaeological sites in the Ring of Fire area recently. And the research that I've been conducting is really about the ongoing tension between the desire for industrial expansion and the fact that the protection of Indigenous ancestral sites within the James Bay lowlands are currently under threat because of recent legislative changes to various acts under the provincial frameworks that were designed to protect ancestral sites. Throughout this presentation, I will be discussing Indigenous burial sites and archaeological sites, and sometimes referring to them as just sites of cultural importance for the ease of my presentation. And to begin with, well, just to roadmap out my presentation, I'll first be talking about the regional assessment in the Ring of Fire area, touch upon the Northern Road Link, anything James hasn't covered. Second, I will be discussing the provincial legal frameworks for protecting sites. And lastly, I'll be discussing some legal jurisprudence from my research. Yeah. Thank you. So, the regional assessment is currently underway in the Ring of Fire area. This process has been governed by the Impact Assessment Act. It's a piece of federal legislation, and the point of conducting the regional assessment in the Ring of Fire area is to understand the positive, negative, and cumulative effects of development in this area. Part of the regional assessment process is understanding, My slides were quite useless, so I can definitely discuss it without them. So the impact assessment currently is looking at understanding the baseline conditions within the region, socioeconomically, the environmental baseline conditions, cultural implications of any proposed developments in the James Bay lowlands. It is the first regional assessment to be co-led with an Indigenous governing body made up of 15 First Nations in the region, alongside the Impact Assessment Agency of Canada. The Regional Assessment Working Group was established in 2023 in order to undertake the various baseline studies in order to understand the conditions on the ground, including engaging with communities about scenario development and mapping, and getting understanding of communities' input into this process. A key component of the regional assessment will be the development of the final regional assessment report, which is supposed to consider the various effects of development and the creation of recommendations in order to avoid any adverse impacts, as well as mitigating any potential impacts of these infrastructure and mining development projects. And this raises a question for me, for my research, to what extent will burial and archaeological sites be taken into consideration, and what mitigation initiatives or proposals are going to be created in order to avoid any adverse impacts on the protection, or adverse impacts on Aboriginal burial sites. And so understanding this question requires me to look into, well, what are the Impact Assessment Act's mechanisms for protecting or affording some protection to these cultural sites of importance? Section 2 of the IAA includes a section which describes that one of the areas of federal jurisdiction are the non-negligible adverse impacts on Indigenous peoples of Canada, including impacts on their physical and cultural heritage, land use and resources, structures, and sites of archaeological significance. What we've seen so far from the regional assessment is that during the draft interim report, one of the cultural assessment priority values that were outlined was connection with the burial sites and protection of these cultural sites of importance. We know that from this report that the Library and Archives of Canada has the expertise and will be doing some work to coordinate with communities in order to share information and maps and knowledge that will hopefully contribute to this protection. However, I think it is fair for us to be concerned about the degree to which the regional assessment will actually help to afford protection to these sites because of the uneven pace which the project level reviews are taking place in relation to the regional assessment in So that does bring me, this is the image, and that does bring me to the Northern Road Link, which, as James described, is this critical connection between the two other major road projects proposed. And one thing to note about the Northern Road Link is that it's currently undergoing a concurrent and coordinated framework of an environmental assessment and an impact assessment with the Federal Impact Assessment Agency of Canada. So this process could also afford some protection to sites of cultural importance, because once the IAAC drafts an impact assessment report and submits this to the Minister of Environment and Climate Change, they can issue a decision as to whether or not to allow the project to proceed. We expect, of course, that this is going to be allowed by the IAAC, and this decision statement created by the IAAC will also potentially create enforceable conditions which relate to the protection of burial sites. And that leads me to, I suppose, the second part of my presentation, which is about what are the provincial legislative frameworks in place in order to deal with the protection of these sites. So, first of all, the Funeral, Burial, and Cremation Services Act, or the FBCSA, is the only provincial legislation in Canada of its kind that explicitly recognizes Aboriginal burial grounds within that legislation. And this piece of legislation essentially creates a mechanism for dealing with the discovery of Aboriginal burial sites. What happens is that the Act allows for the creation of a site disposition agreement once a site is discovered and a landowner is forced to preserve any remains that are found on their piece of land. The creation of a site disposition agreement between a landowner and a nearby Indigenous group to which the remains belong to or culturally belong to allows for a negotiation or perhaps a mediation to take place, which will govern the protection of these sites. As well, the Ontario Heritage Act complements this by regulating archaeological fieldwork and the removal of artifacts. Traditionally, these two acts work in conjunction with one another when industrial projects find that heritage sites are within their areas of work. However, the legal landscape is quickly shifting. And in June 2025, with the passage of the Protect Ontario by Unleashing Our Economy Act, I'll refer to it as PUIA, amended the OHA to streamline approvals for the provincial priorities. The PUIA essentially changed OHA in order to centralize control over the processes for archaeological site identification and protection. It also created mechanisms to bypass these legislative processes, and also has created sections that limit the Crown's liability for any of the changes that were done to the OHA and the other relevant legislation. So some of the key points that I've looked into in my research are sections of the OHA, for instance, section 66.1, which allows the provincial cabinet to have the discretionary authority to exempt certain projects from regulations under the OHA and the FBCSA, if they believe that it advances infrastructure goals. Giving this high level of discretionary authority to the Ontario legislature to the minister in order to nullify OHA and FBCSA laws raises concerns that potentially all of these projects and essentially the minister's response to the denial for a request for Eagle's Nest mine demonstrates that the federal government is essentially minimizing its role and taking a step back, even though they know what changes have been made to recent Ontario legislation, which will in fact cause areas of federal jurisdiction, including these Indigenous burial sites, to be destroyed or potentially damaged through the creation of these infrastructure projects. As well, most concerningly, I think, in the OHA amendments was section 66.2, which attempts to extinguish legal causes of action against the Crown arising from these exemptions. In effect, these amendments add up to the province's attempt to bypass protections to safeguard ancestral remains in the path of projects such as the Northern Road Link. And Given these various changes, it has led me to look into some of the jurisprudence and legal strategies that have been pursued in order to continue to protect these sites in different provinces and as well as Ontario. So, yes, this is a slide. So, in terms of legislative frameworks to trigger protections for these sites, of course we have the FBCSA, a stop work trigger, which happens when there's the discovery of human remains. Even a single fragment of a human remain would immediately trigger this legislation and compel the Registrar of Cemeteries to investigate and determine the cultural origins of human remains. And this would lead to a site disposition agreement, which would hopefully lead to First Nations communities negotiating what to do with human remains found in the way of work sites. A second strategy that is found in various cases across Canada has to do with demands for interlocutory relief. So there have been several projects across Canada which have got started and were stopped because of the discovery of sites of archaeological significance. One of the most important cases in Canadian jurisprudence is McCready in Ontario. This case was essentially dealing with the High Falls Power Dam, and this was occurring in, I believe, the early 1990s. Essentially, Nipigon Power wanted to construct a dam, and the discovery of human remains led to the Poplar Point Ojibwe Band Council requesting a court for an injunction to stop any construction processes. What subsequently happened in this case was that the courts applied a balance of convenience test. This is what is typically done in order to balance the demands of industrial development against the demands for cultural protection for Indigenous communities. And this case was one of the few successful cases, I would say, that in which the court found that the destruction of a burial site would cause irreparable harm to a fundamental tenet of Indigenous culture that money could simply not fix whatsoever. Overall, this case was a lose-lose situation because of the way in which the burial site was discovered, the length of the litigation, and the fact that already there were sites that were destroyed throughout the construction of the High Falls Power Dam, and yet the Nipigon Power Company was not able to profitably even operate the dam in the end. Furthermore, there are other cases in Ontario, such as the Ontario Heritage Trust and Hunter case that was recently ruled upon in 2025. The court found in this case that the Indigenous burial interests transcend the concerns of ordinary property law. It rejected the idea that developers could simply pay a fine for encroaching upon sacred land and ordering instead the full removal of structures that were created illegally on sites of spiritual integrity. Which also leads me to the third case, which I can discuss briefly, Kataquapit Nation in British Columbia in 2016. This case, however, showed that courts are not willing to be as flexible as many legal strategists previously thought with regards to the protection of religious sites or sites of spiritual significance. It raised the bar for lawyers to make the argument that some protection should be afforded on the basis of Aboriginal rights relating to spiritual belief. Finally, I want to just briefly discuss non-legal strategies such as protests and blockades. This was seen in both the McCready case as well as the recent litigation against Bill C5 and Bill 5 by several Ontario First Nations communities. These non-legal strategies have the ability to force the Crown to the negotiating table, and these litigations against Bill 5 and Bill C5 will likely transform the landscape once again with respect to the amendments that were done to the OHA and the FBCSA. Today, what I have concluded is that the archaeological oversight is in jeopardy, and depending on the outcome of this litigation against Bill 5 and Bill C5, we're unsure of how First Nations communities will be able to proceed with the protection of archaeological sites and burial sites within their traditional territories, and this leads to questions of what will happen with the Northern Road Link project, and I'm still working on what would be the best course of action to take in terms of the protection of these sites. Thank you very much.
Okay, thanks everybody. I think we have maybe about 10 or 15 minutes for questions. So just to remind everybody, we do have another panel following this one. We're going to hear more about special economic zones, the PONIs, the projects of national interest, as well as some further action that's been taken with respect to the fast-tracking legislation. But if anyone has questions on these presentations, we're happy to do that now. Or comments, or generally, Henry.
This might be more for James, just because I thought I was really interested in your presentation when you were speaking about the fact that these independent companies need sort of these government subsidies to build the road. I guess I was just wondering, in your research, have you seen any sort of economic studies or any sort of actual logical assessments of whether or not this is a good idea financially, or is it just more of a we'll figure it out, hope this works?
So the only economic studies I've seen were from the Cliffs proposal in 2011. And basically I was able to look at a 2012 presentation internally that Cliffs made, where basically they said that a roadway would be the best place to start because it offered the best balance between being a relatively cheap option to start, at least compared to a railway. And it would also, for at least the first 10 to 20 years of the lifespans of the mines up there, be good enough in terms of getting enough ore out at a cheap enough cost that you know, the operation could be continued. They really didn't like the east-west road just because due to the nature of how like chromite pricing kind of works, it's this kind of up and down cycle. If the price of shipping, sorry, if the price of selling the chromite is lower than the cost of shipping it out of the Ring of Fire, did I say that wrong? Either way, if it's not viable, if that relationship becomes so that it's unviable to ship chromite out of the Ring of Fire, the road is just going to be shut down and abandoned. And so the east-west road made it more likely that the road would be shut down more often. So that's why they really wanted the north-south road, because they said it makes it cheap enough to get stuff out that we can get the ventures up and running to ship the chromite out, but it also is, it's not as expensive. And yeah, and then they also liked it because in the future it would then support a railroad, and it's kind of like, it's a way to kind of backdoor a railroad in, because up front the cost of a railroad would be ridiculous. In 2013 it was something like $2 billion, and I still think at this time, just looking at the numbers that were being thrown around from studies out there, that mining companies had not begun to realize how expensive it would be to build a road into the Ring of Fire. So the actual amount would be much, much higher. So that's why they went with the road as the starting point, is it's cheap, and it's good enough to get mining up and running in the region, but then in the long run, it could support a railroad as well.
Yeah, so it's a bit of a chicken and egg problem, I think, as well. With, you know, the mining companies don't want to do their feasibility studies until they see the roads are in, and Ontario doesn't want to talk about how much the roads are going to cost, who's going to own them, who's going to hold the liability. They don't want to talk about any of that right now, right? So the $2 billion estimate is still the one floating out there. Ontario says they'll pitch in $1 billion. They want the feds to match. Everybody knows it's going to cost way more than that, take way longer than they predict, right? It's technologically very difficult. There's this floating road proposal that nobody knows whether it's going to work, right? So it's a bit of a dance between the mining companies who don't want to do their feasibility studies until they know the state is going to subsidize all this infrastructure, and the state doesn't really want to say how much it's going to cost until it's approved. And I suspect we'll kind of see some coordinated announcement at some point about that, but it's kind of where it is right now. It's a good question. Does anybody else want to ask anything right now? Yeah, go ahead.
My question is on the roads in themselves. Like, I know Ontario just announced that they're planning to have the roads built by 2031, but I guess given how complicated it is to actually build the road, do you think that by the time that they even get the road out there, any economic case of even buying those particular minerals, which I don't think there was much on the first place, will be gone because there will be will be at a more advanced stage in terms of critical minerals and what we need for clean energy.
So I'm gonna need a second to think about my answer to that. Dayna, do you have anything just off the cuff?
Yeah, I mean, I think, again, none of us really know, right? So the commodity prices go up and down. The technology is changing, right? So people are saying, yeah, we need nickel for electric vehicle batteries, but other folks are saying, oh no, we're gonna go to sodium batteries. When, you know, if they take 8 years to build this road, which is probably on the low end, then we might not need that nickel anymore, right? And so that's why, in part, the strategy of a lot of First Nations is to try to delay, right? Because there is a chance that people will walk away from this and they will decide they don't want to disrupt this territory. But we don't know. We don't know the direction this is rolling in, I don't think.
I think in terms of talking about the economic feasibility, there's also, just because these projects are so far away in terms of getting the roads built and then actually getting these mines operational. To speak to Dayna's point that she brought up before about warmongering and how these mineral resources are being used in order to fuel industrial war machines, I think that recent discussion by the U.S. administration to form a trading bloc of countries in order to price control essentially critical mineral resources because of this ramping competition with China also throws up so many uncertainties about the degree to which Canada's minerals are going to be needed, because apparently there's going to be more global demand and more global supply chains connecting other countries to essentially those supply chains. So who knows if Ontario's resources will be competitive, or if maybe it will be extremely competitive due to some sort of trade bloc.
Good point.
And I'll just throw into that the nickel mining may ultimately become, there still may be a case to be made for that, because that seems to be profitable even with a road being built. And at this point, the Northern Road Link will probably be built. But I don't think that we're ever going to see, or it seems highly unlikely that if there are any delays that we're going to see chromite mining, just because it's just so much more expensive to get the infrastructure for that up and running.
Yeah, and then there's the question of the smelters. Where are they going to build the smelters? Is that going to be also in Ontario? Is it going to be close enough to make it profitable? Are those places going to want smelters? All of those questions are still up in the air as well. Jeronimo?
So I suppose the question I have is, since we're talking about these long timelines, there is a chance that the government could change within those.
True.
Within these times of 8 years or so, 6 years. What would happen to these? Would that change the timelines or how the projects proceed if there is a government change?
Good question. I think it depends what kind of government change we're talking about. Yeah, and I can't make any predictions on that, but the price match is not there from the feds right now, but so much money is being flown into exploration by the federal government right now, and subsidies, and as you know, the Indigenous loan guarantee programs and all of that pushing of the equity partnerships as well. They're willing to put a lot of money into that right now. The flow through shares to finance exploration, a lot of money is going into that. So, would they be willing to spend $1 billion? It seems like they would be, but I don't know if they want to do it in this particular way. Yeah, so I think it's as you say, really open question, because we are talking about long timelines, and folks here will know, and you will know, it's already been on the table a decade or more, right? So when they say, it's been 12 years and we haven't seen any shovels in the ground, we say, yeah. Let's go for 12 more, maybe. I don't know if you guys want to add anything. All right, folks, so let's take a quick break. I'm going to suggest we keep it to between 5 and 10 minutes.
Thank you.
Hi, everyone. Thank you all for coming today. My name is Allie. I'm a second-year law school student here at Osgoode, and I'm also a student in Professor Scott's Environmental Justice and Sustainability Clinic. Over the past academic year, the clinic has created and recently submitted a shadow report to the United Nations Human Rights Committee, examining the implementation of recent fast-tracking legislation and the implications that these laws have on Indigenous self-determination and democratic participation within Canada. Today I'll be discussing the legislation at issue within the report, the rights engaged under international law, and the advocacy tool that we took. In particular, the concerns I'll be discussing arise from the Federal Building Canada Act and the Special Economic Zones Act, which is Schedule 9 of what Skye referred to earlier as the PUYA. Framed as urgent responses to economic instability following the tariffs imposed by the United States, these laws were allegedly introduced as strategic legislative responses aimed at mitigating economic uncertainty by fast-tracking certain types of major development and infrastructure projects. For example, at the federal level, the Building Canada Act, or the BCA, creates a framework to accelerate projects the government designates as being within the national interest, also commonly referred to as PONIs. Once designated, PONIs can receive advance approval through a streamlined process. This, in practice, gives Cabinet and the Minister authority to override or sidestep existing legal safeguards, including, for example, those found in the Impact Assessment Act and the Fisheries Act. At the provincial level, the Special Economic Zones Act, the SEZ Act, grants Lieutenant Governor and Council, the provincial cabinet, expansive and undefined powers to pass regulations designating areas. Oh, I didn't start at my time. I'm so sorry. Undefined powers to pass regulations designating areas of the province as special economic zones. This allows the provincial executive to bypass the legislator's role and unilaterally abandon existing laws and regulations, including those that detail criteria for permits, approvals, and environmental protections. While Doug Ford has recently informed us that he does not need to pursue the Ring of Fire through this legislation, the SEZ Act and the BCA nonetheless transfer sweeping decision-making power from established legislative and regulatory processes to the executive branch of their respective governments. This raises serious concerns about transparency, accountability, and democratic participation. It is against this backdrop that the clinic chose to pursue an international avenue of advocacy and preparing and submitting a shadow report to the United Nations Human Rights Committee. The Human Rights Committee is a body of 18 independent experts responsible for monitoring the implementation of the International Covenant on Civil and Political Rights by its state parties. States that have ratified the covenant, such as Canada, are responsible and required to submit regular reports to the committee explaining how civil and political rights are being implemented domestically. The committee then reviews these reports and issues its concerns and recommendations in the form of concluding observations. However, before those observations are finalized, the committee invites non-governmental organizations, NGOs, and civil society organizations to submit their own reports. These reports are commonly referred to as shadow reports, and they allow NGOs and civil society organizations to supplement and present alternative information to those submitted by state governments. Our report argues that the implementation of the SEZ Act and the BCA undermine two core rights protected underneath the covenant. Article 1, the right to self-determination, and Article 25, the right to participate meaningfully in public affairs. Turning first to Article 1, I think so. Is it first? Okay, cool. Turning first to Article 1, the covenant grants all people the right to self-determination, meaning that they may freely determine their political status and pursue their own economic, social, and cultural development. In Canada, the concept of self-determination is understood broadly to include the need to recognize and advance Indigenous peoples' jurisdiction as a central feature of successful, legitimate, and accountable governance. A key aspect of this understanding is the degree to which Indigenous peoples are regaining control over their own lands and resources. In the context of the SEZ Act, the legislation enables Cabinet and the Minister to create lawless zones where the provincial executive, instead of the legislator, has the final decision regarding which regulations do or don't apply, ultimately overriding the will of Indigenous governance. By removing these mechanisms that trigger the consultation process, including the need for permits and approvals, special economic zones effectively erase constitutionally required opportunities for Indigenous voices to be heard. Therefore, in practice, these economic zones make meaningful consultation nearly impossible, as well as completely preclude a right to consent. Similarly, the BCA Act allows PONIs to be pre-approved. This pre-authorization does not allow for meaningful consultation or accommodation of potentially impacted Indigenous communities. In this way, the BCA, like the SEZ Act, prejudges consent and effectively removes the ability of Indigenous communities to influence government decisions over their own economic and governance affairs. Furthermore, the designation of PONIs has implications for the application of related processes, including Crown consultation. The BCA's streamlined federal approval and permitting process bypasses the regulatory and environmental reviews necessary to give effect to the Government of Canada's duty to consult. Bypassing these processes creates uncertainty as to how the Government of Canada intends to uphold its constitutional obligations to Indigenous peoples under Section 35 of the Constitution. Taken together, these legislative changes significantly restrict Indigenous communities' ability to shape their own economic and social futures, a core component of self-determination. Turning now to Article 25. Article 25 of the Covenant guarantees all people the opportunity to take part in the conduct of public affairs, either directly or through their freely chosen representative. This participatory right is reflected in Canada's legislative process. When a bill is introduced, the executive, alongside the legislator and civil society, engage in democratic dialogue regarding the contents of the proposed bill. Both the SEZ Act and the BCA disrupt that structure. The SEZ Act introduces undefined terms such as trusted proponents and designated projects and leaves their interpretation largely dependent on the opinion or the satisfaction of the relevant provincial minister or lieutenant governor in council. However, in order for democratic dialogue to function effectively, the executive cannot take crucial decisions out of the legislative branch and give the authority over to the members of the executive with no oversight. When this happens, the affected Indigenous community, neither affected Indigenous communities nor the public and civil society can meaningfully affect decision-making on matters of significance to them. Accordingly, should Canadians or Indigenous communities disagree or take issue with the meaning the minister has chosen to assign to these undefined terms, they will be unable to engage through their elected representative. Similarly, the BCA also grants significant discretionary powers to the executive branch of the federal government. In sections 21, 22, and 23 of the BCA, the executive is granted largely unrestricted authority to modify or exempt the application of almost any law in the federal statute book. Section 21(1) of the BCA further grants the federal cabinet the authority to amend the list of laws that may be exempted from application, therefore shifting the authority to the executive branch and removing the power from the House of Commons. This legislative form, known as the Henry VIII Clause, is of particular concern for the application of Article 25. As this act of shifting power effectively disenfranchises all Canadians, but especially those who are significantly and adversely affected by these new resource extraction projects. If decisions about designation of projects and the list of laws that can be ignored are not required to go through the House of Commons, then people in Canada are not able to take part in the conduct of public affairs, either directly or through their freely chosen representative. It is based on these findings that our submission asked the United Nations Committee to recommend Canada take the following 4 steps. To first, recognize the violations that both these laws have on the public and Indigenous peoples and their ability to engage in the democratic process and exercise their self-determination. Second, appropriately consult with and seek the free, prior, and informed consent of impacted and affected Indigenous communities as a way of supporting their self-determination. Third, facilitate the integration and support of the public and Indigenous participation within the implementation of both these acts. And finally, repeal and/or amend with the full equitable participation of Indigenous peoples and the public, both the SEZ Act and the BCA, to restore the self-determination and democratic rights of Indigenous peoples and Canadians. While the committee's decision to adopt these recommendations is completely voluntary and will not yield a legally binding result, the process of submitting this report was nonetheless an important tool for advocacy and accountability. As noted by Amnesty International, shadow reports highlight how human rights are being experienced in practice beyond what governments report of themselves. They bring international attention between gaps in commitments and lived reality and create a space for public awareness and compliance. Canada has long positioned itself as a global leader in human rights, and submissions like this invite the international community to ask whether that reputation is truly deserved, as well as provide a platform to let organizations like the Clinic ask Canada to do better. Thank you very much.
Okay, hi everyone. My name's Alex. I'm also a second-year student at Osgoode's Environmental Justice and Sustainability Clinic, and my presentation will discuss the Building Canada Act, projects of national interest, or PONIs, and Ring of Fire projects. And specifically, my research involved working with Neskantaga First Nation on arguments that support their position that Ring of Fire projects are not in the national interest. And I speak about Ring of Fire projects fairly generally in this presentation. The focus of my research was particularly Wyloo Metals' Eagle's Nest mine and the Northern Road Link. Per updates this week, it seems like Wyloo is not going to be pursuing the Building Canada Act process or the Major Projects Office referral process for Eagle's Nest mine, but I think the arguments that I made pertain to Ring of Fire mining in general, so I'll carry on. But I'll refer just generally to Ring of Fire projects for ease. And I'll start by providing a basic introduction to the Building Canada Act, the Major Projects Office, and explain the differences between the two, and the processes through which projects get designated as PONIs. And then I'll discuss some of the arguments that I made to support my claim that Ring of Fire projects aren't in the national interest. So some background on the Building Canada Act. So it was passed on June 26, 2025, and it permits the Governor and Council or Cabinet to designate major projects as PONIs. And so far, no projects have been designated. Maybe they never will. But 11 projects have been referred to the Major Projects Office as nation-building projects. And you can see on the map on the slides where those are in Canada. And being referred to the Major Projects Office comes with its own benefits, which I'll explain in a second. But first, the Building Canada Act specifies 5 criteria that Cabinet may consider in deciding whether to designate a project. The Major Projects Office also considers these 5 criteria. And they're not mandatory factors, but they are relevant, and they include the extent to which a project can, A, strengthen Canada's autonomy, resilience, and security, B, provide economic or other benefits to Canada, C, have a high likelihood of successful execution, D, advance the interests of Indigenous peoples, and E, contribute to clean growth and to meeting Canada's objectives with respect to climate change. Okay, so my apologies if this is hard to see. I'm not very good at Canva, but I'll explain what it says even if you can't read the text. So I'm just gonna explain a little bit about the processes through which projects get designated and what it means to be a normal project versus a referred project or a nation-building project or a PONI, a project of national interest. So the first step is that a project is submitted to the Major Projects Office, and this is what Wyloo has stated that they're not interested in doing. They're not going to submit Eagle's Nest to the Major Projects Office for consideration. And then the Major Projects Office then evaluates that project using those 5 criteria, and if they determine that a project is of sufficient national significance, they get approval from the Prime Minister, and then a project gets referred. So what does that mean? It essentially means that a project now receives the full backing and support of the Major Projects Office, and that may include help securing financing for projects, coordinating regulatory approvals, helping projects navigate federal processes, and providing guidance, advice, and planning support. However, referred projects are still like normal projects in that they still need the necessary permits, licenses, and approvals that they normally would need to proceed, and all federal laws, including environmental laws, still apply to the project. So they just get this sort of added boost of support, essentially. But a project may also go on to be formally designated as a PONI under the Building Canada Act and through being added to Schedule 1 of the Act. And again, this hasn't happened yet, but once a project is designated, as Ali mentioned, it's essentially pre-approved. And the federal government has stated that the focus then shifts from whether a project will proceed to how it gets built. And now it can be exempted from listed federal statutes and regulations in Schedule 2 of the Building Canada Act, and those include the Impact Assessment Act, the Species at Risk Act, the Fisheries Act, and other bedrock federal environmental laws. And more may also later be added. And PONIs are also automatically deemed to meet the environmental and safety standards normally required under federal laws, and they're issued something called a conditions document that replaces all of the permits and licenses and approvals that they would normally need to move forward. And in order to receive that conditions document, proponents still need to prove that they meet the conditions and criteria that they normally would to receive it. However, let's say if a PONI gets exempted from the Fisheries Act, and it normally needs an authorization under the Fisheries Act, then it no longer needs to meet those criteria that it would need to receive the authorization. My apologies if that's confusing. I'm happy to answer any questions on that. And then also impact assessment. So impact assessment is one of the laws already listed on Schedule 2. It may be exempted from projects, but then if it does happen, the 6-month planning period no longer applies, and that's really critical for Indigenous engagement and public involvement on scoping the issues, but it no longer happens if a project is designated. Okay, so moving on to the arguments that I made for my research. So I'm going to go through each of the 5 criteria that are specified in the Building Canada Act and make some arguments for why projects in the Ring of Fire don't meet those criteria. So starting with advancing the interests of Indigenous peoples, of course, Indigenous peoples are not a monolith. There's not one view on Ring of Fire projects in communities, but my research is on behalf of Neskantaga First Nation, so I'm coming from that perspective. And I made 2 overarching arguments supporting here for this point. So the first is that Ring of Fire projects don't advance the interests of Indigenous peoples, and the second is that the process of designation under the Building Canada Act also doesn't advance Indigenous interests. Ali touched on that when she was talking about self-determination, so I'll focus a little bit more on the first one. So for the first part, so if you can see on this map, that purple outline is Treaty 9, and all the communities within that are Treaty 9 communities. And Treaty 9 communities, like Neskantaga, are currently facing overlapping social and health crises stemming from systemic infrastructural neglect. And communities are faced with inadequate health and mental health care and facilities, inadequate housing, education, and lack of clean drinking water, as was discussed earlier. And so it means that communities are stretched thin already. They're under-resourced, and they don't necessarily have the capacity to address all of the extensive changes that come with mining. And these changes include bringing, potentially, as we know, resource extraction on Indigenous lands comes with crime, drugs, and alcohol in communities, increased rates of violence. It's linked to the missing and murdered Indigenous women, girls, and Two-Spirit people crisis. And it also necessarily reduces access to land and First Nations' ability to exercise their treaty rights and their inherent rights. And there may also be other impacts on those rights from tailing spills and environmental contamination, and also on the non-human beings that live on that land. Also impacts on burial sites and things like that, as Skye mentioned. And then also, there's issues and questions about whether the duty to consult can be properly discharged under the Act. And the Crown has this constitutional duty to consult with Indigenous peoples and accommodate if required under Section 35 of the Constitution Act 1982. But if there's pre-approval, then is that really meaningful good faith consultation, which is required? And also, consultation takes time, and the Building Canada Act has these fast-tracking timelines. It's trying to push things through really quickly, and that doesn't necessarily align with meaningful consultation. Additionally, again, from adopting this sort of from whether to how approach, the federal government is essentially saying that First Nations can't say no to projects, which is contrary to the right to free, prior, and informed consent, as affirmed in the United Nations Declaration on the Rights of Indigenous Peoples. And the Supreme Court of Canada has held that UNDRIP is now part of Canada's domestic positive law. And also, pushing through projects without consent ignores the nation-to-nation partnerships agreed to by Canada as a signatory to Treaty 9. Okay, And then, so why don't Ring of Fire projects satisfy the factor of contributing to clean growth and to addressing climate change? So again, if you can look in the map, that green part there is the Hudson Bay lowlands, which are the world's second largest peatland complex, so super vast, massive peatlands. And peatlands are carbon storage powerhouses. They're the world's largest and densest terrestrial carbon storage ecosystems, and they store more carbon overall than in all of the world's forests. And if peatland's disturbed, then carbon gets released. It's a little bit more complicated than that. You can look at the graphic for more detail, but the total carbon stored in the Hudson Bay lowlands is around 30 gigatons, which is roughly 60% of global emissions in 2024. And the total carbon at risk from Ring of Fire development, so from where mining claims are staked and from where roads are set to go, is around 700 megatons, which is approximately 3 times Canada's 2023 greenhouse gas emissions. So peatland disturbance in the Ring of Fire could have a very big impact on climate change in terms of releasing carbon. But peatlands are also vital for biodiversity, for maintaining air and water quality, and for climate resilience. But if they're drained or they're not healthy, then they can have the opposite effect, so they can catch on fire really easily, and then that releases even more carbon into the atmosphere. And as was discussed by Professor Scott in the beginning, historically there's been this narrative that we need the Ring of Fire for the energy transition, less so now. But it's important to note that even if every mineral extracted from the Ring of Fire went towards EVs, electric vehicles, for example, the scale of the climate impacts from peatland disturbance could potentially reverse any sort of progress made on that front. Okay, so the last 3 criteria. So the first is providing economic or other benefits to Canada. So again, as was discussed in the first panel, there's sort of these questions about what the actual economic benefits are, and there's also, it's very costly to make mining viable in the Ring of Fire, so the return on investment is uncertain, I would say. And I also made the argument that since disturbing northern peatlands will potentially accelerate climate change, then Canada should consider the economic costs of climate change itself when evaluating the value of Ring of Fire projects. And climate change will be costly for Canada, and in fact it already is. But for example, Canada stands to lose around $100 billion a year by 2050 in a high emission scenario compared to a more stable climate GDP. Climate change will increase government costs for infrastructure, healthcare, and extreme weather disaster responses, but job losses and income and productivity decreases will occur, but then taxes will increase from government costs. So essentially, the amount of money that the average Canadian has will lessen. And there's also non-economic costs, as I mentioned earlier. So there's these environmental, cultural, and social costs, and those need to be accounted for too and considered. And there's a lot of uncertainty here in terms of what those impacts will be, and that really highlights the need for a more cautious, deliberate, careful approach rather than fast-tracking and pushing things through really quickly. And then in terms of having a high likelihood of successful execution, so there's some barriers to successful execution, as was mentioned before. There's practical challenges of building on peat. It's not a stable substrate, it's very wet, and so that creates an issue for building roads. Maybe there's this floating roads thing, beyond just building on the eskers, but for the parts that have to go over peatland, but that can't really tolerate very high volumes of minerals. So there's some uncertainty there. There's also existing legal challenges, as was mentioned earlier. So there's been legal challenges to the Building Canada Act, the Ontario equivalent, and there's an existing Treaty 9 action, which challenges the validity of federal and provincial laws, so that creates some uncertainty. There's also ongoing legal challenges to the Ontario Mining Act and Ontario's free entry mining regime, and those have similar challenges in other provinces have been successful. So maybe they'll be successful here, who knows, hopefully. There could also be an UNDRIP or a duty to consult challenge to the Building Canada Act once projects are actually designated. And maybe, there's lots of different ways that there could be barriers here, and so that creates some uncertainty. And then also, as was mentioned earlier and will be discussed further, there's the possibility of land defense actions, which create on-the-ground sort of barriers to successful execution. Here we stand is an example, and it just shows that communities have the will to engage in on-the-ground land defense, and that's something that may happen if projects are designated. And then finally, strengthening Canada's autonomy, resilience, and security. So fundamentally, positive relationships with Indigenous peoples are critical for Canada's autonomy, resilience, and security. And in the Treaty 9 context, I made the argument that Canada needs to address the social and health crises faced by communities and treat them as treaty partners instead of pushing through projects without consent. And I will conclude with this quote by Ontario Ombudsman Paul Dubé, which is from after he visited Neskantaga last September. And he says, "Governments committed to the reduction of red tape would do well to prioritize eliminating the red tape that deprives remote Indigenous communities of safe drinking water and adequate funding for healthcare, education, and infrastructure. This is not only a legal and moral obligation, it is an opportunity for Ontario and Canada to demonstrate genuine reconciliation through meaningful, lasting change." And that concludes my presentation. Thank you.
Has that one changed?
It's not changed. Now it is.
Oh, that is perfect. All right. Hello, everyone. My name is Will, and I'm here to talk to you today about special economic zones. Now, I had a fairly different presentation in mind until about Monday, but there was a big announcement at the Prospectors and Developers Association of Canada's mining convention by Premier Doug Ford, where he said that the provincial government would no longer be interested in designating special economic zones for rain of fire development. And so this year I've been working in the clinic for Neskantaga to kind of think of arguments for why the rain of fire should not be designated as a special economic zone. And, oh, can you hear me now? Is that better now? Perfect. And so while the provincial government has made it known that they no longer will plan to use these special economic zones, I still think it's important for us to go through kind of what these special economic zones are, what the criteria are for their designation, because the power still exists until this provincial legislation is repealed. Now, so earlier this year, through Bill 5, the provincial government spearheaded this legislation that allowed them to designate and create special economic zones. Now, under the Special Economic Zones Act, or CEZA, the Lieutenant Governor and Council, which means the provincial cabinet, has the power to make regulations that modify or remove requirements in provincial laws as they would otherwise apply to, quote, trusted proponents or designated projects in special economic zones. Now, in other words, this means that CEZA provides Ford's government with the power to render inoperable whatever provincial law it desires for projects and their proponents in special economic zones, including laws related to environmental protection, heritage preservation, and environmental assessment. Now, special economic zones are designated by the Lieutenant Governor and Council, the cabinet, while trusted proponents and designated projects are designated by the Minister of Economic Development, Job Creation, and Trade. Now, importantly, the criteria for designating SCZs, trusted proponents, and designated projects was not included in CEZA itself, but the power to create those criteria was delegated to the Lieutenant Governor and Council to be put forward in a future regulation. And after a public comment period on January 1st of 2026, the criteria for designation was issued in a regulation by the provincial government, and this had criteria for designating the special economic zones, the trusted proponents, and the designated projects. Now, I'm not going to take you on a line-by-line, step-by-step process through all the criteria for designation, but I'm going to highlight the ones or the components that I think are the most problematic and the most the things that we want to be aware of for why these zones should not be designated. Now, to designate a special economic zone, the Lieutenant Governor and Council has to be of the opinion that there will be activities in this area that will be economically significant or strategically important to the Ontario economy. And the very important thing to note there is that this is in the opinion of the Lieutenant Governor and Council. There's no requirement for the provincial government to seek the consent of Indigenous peoples that live in this area or for any consultation to determine whether these activities will be economically significant or strategically important. And there's no mention in this criteria for whether these activities will be environmentally harmful or whether there are other concerns that the public may have for this designation. And further, the minister has to be of the opinion that the area will be no larger than necessary for these activities. But again, the same concern holds that this is entirely within the discretion of the provincial government, and there is no requirement for them to consult to determine whether this area is too large or too small. Now, for trusted proponents, these proponents could be the Crown itself, it could be a Crown agency, it could be a not-for-profit, but importantly, proponents can be corporations, like the ones that own these mining projects. And if the proponent is of a designated project is a corporation, there are certain requirements for designation that are laid out in the regulation. The corporation must have a good record of complying with legal requirements, including requirements related to health and safety protection, environmental protections, employment standards, and financial matters. But importantly, as we saw with the previous criteria, this is entirely within the discretion of the minister in this case. And there's no requirement that communities that this proponent would be working near or with believe that this is a good record. Further, the corporation has to give reassurances that everyone with whom the corporation is contracted to work on the project has a good record of complying with those legal requirements. Again, the same concern of it being entirely within the discretion of the minister. Now, importantly, if the corporation will need to engage with Indigenous communities to carry on the project, which it certainly will need to if it's a Ring of Fire project, the minister has to be of the opinion that the corporation has a plan for engaging and working with Indigenous communities. There is no requirement that this plan be accepted by those Indigenous communities. There's no requirement that those Indigenous communities be consulted on this plan. The minister must also be satisfied that at least some individuals working on the project have a history of working successfully with Indigenous communities on projects in Canada. Again, the same concern arises again and again about the lack of true consultation and consent from Indigenous communities on these project proponents. Now, there is, moving on to the designated projects. In order for the project to be designated as a designated project, the minister must be of the opinion that the project will have significant long-term economic benefits for Ontario. And now the regulation provides several factors that the minister may consider when determining this, but importantly, it allows the minister to consider such other factors as the minister considers appropriate. And this gives an incredibly wide berth to the minister to basically consider any factor they desire to justify their decision to designate a project under the Act. The minister must also be of the opinion that the project will benefit communities in Ontario. And as one of the factors in this determination, they may consider whether it will benefit communities within a special economic zone, communities without, but there's no requirement of exactly whom this project will have to benefit. And again, the minister may consider any factors it wants to justify its decision. The minister must be of the opinion that the project is likely to succeed. The same discretion applies here. And finally, the minister must also be of the opinion that the exemptions and modifications that are possible through designation under the Act will make it possible to complete the project more quickly and will increase the likelihood of the project being successful. And obviously, exempting or lowering requirements under provincial law for a project will allow the project to be completed more quickly. Now, moving back to PDAC, the Ontario government has not yet exercised its power to designate any SEZs, trusted proponents, or designated projects under CESA. And according to Ford at PDAC, Ontario does not plan to use its power to designate any SEZs in the Ring of Fire in the near future. Now, Doug Ford has harked on to no end about the need to remove regulatory red tape so that we can unlock Ontario's true economic potential through critical mineral extraction. CESA was enacted in this rush to expedite development, and yet, according to Premier Ford, his government no longer believes it will be necessary to designate SEZs. But why? As Premier Ford explained at PDAC, we don't need it when you have great partners. They're excited. They want to move forward. And Ford continued, what's the reasons you need it when you have incredible partners like Chief Lorraine, Chief Bruce, Chief Sonny at Allan, and others right across the province? So there's no reason to use it. Let's move forward and get these things done. Doug Ford believes that he has all the support he needs from First Nations in the Ring of Fire to get things started. Any designations under CESA would be unnecessary. Now, pardon me, clearly this is not the case. Ontario has recently signed agreements with 2 First Nations near the Ring of Fire, Martin Falls and Webekwe. These nations have agreed to support extractive development in the Ring of Fire in return for the construction of permanent road access to these communities, as was discussed earlier. Both Martin Falls and Webekwe have recently submitted environmental assessments for those road projects. But Martin Falls and Webekwe are not the only First Nations in the Ring of Fire. Ontario has not received the consent of these other First Nations. In fact, many of these nations have expressly withheld their consent to development in and affecting their territories. These nations call out Ontario's lack of respect for their inherent jurisdiction and decision-making authority over their homelands to the destruction of their very ways of life. Can the consent of 1 or 2 First Nations suffice in place of the consent of all? Surely not. Major project development in the Ring of Fire will impact the territories of many First Nations. Each of these nations has not only the right, but the obligation to decide what's best for their lands, their people, and their generations yet to come. Ontario has no right to interfere with this decision-making process, to divide and conquer, to exploit the precarious situation of many of these communities. Ontario's retreat from the use of special economic zones is welcome, but Ford's confidence is misplaced. Many First Nations stand united in defense of their homelands, of their inherent jurisdiction and decision-making authority, of their relations to the human and more than human world. If and when the provincial government or private actors threaten these obligations, these nations will not sit idly by. In a recent opinion of a reference case, the Supreme Court of Canada found that the United Nations Declaration on the Rights of Indigenous Peoples has been incorporated into Canada's domestic law. Courts across Canada have only begun now to reckon with the consequences of this incorporation, particularly the relationship between the principle of free, prior, and informed consent and Section 35 of the Constitution Act 1982. The honor of the Crown, which is always at stake in the Crown's dealings with Indigenous peoples, requires that the obligation to seek and secure free, prior, and informed consent applies not only to the federal government, but to provincial governments like Ontario. Without the consent of all First Nations in the Ring of Fire, there can be no project development. Any such action would breach the Crown's constitutional obligations to First Nations in Treaty 9 territory with whom the Crown shares decision-making authority. With or without special economic zones, Ontario does not have the power to fast-track its way around the inherent jurisdiction of First Nations. That concludes my presentation. Thank you for listening.
Okay, how about another round of applause for all my students? Okay, so yeah, we have 15 or 20 minutes for questions. I'm going to start back there and I'll come to you, Rohan. Ava.
Great job, everyone. I had a question for Ali. I was wondering how did you land on pursuing a shadow report and whether you explored different options? Landing on what?
Thanks, Ava. In the beginning of the semester, we debated between a shadow report and a formal complaint to the UN committee, but we decided after doing some research that the formal complaint required us to exhaust all domestic remedies, including court proceedings, and like if the court proceedings weren't successful, then appealing those decisions as well. So just given resources and time within the clinic, we decided that it made more sense to do the shadow report in like respect for everybody else's resources and time. And because they both don't, the formal complaint and the shadow report both don't yield legally binding results, it just made more sense economically and in terms of time to do the shadow report.
Want to mention your partners, maybe?
Yes. We also partnered with, I've been really privileged this semester to work with Carrie Blaze, the founder of Legal Advocates for Nature's Defense. I've been with her since September, and she has graciously signed on to our submission, as well as the Mining Watch, Jamie Neen. So they partnered with us, and we were able to get their support for the shadow report. So it just made more sense if we had their support and in respect for everybody else's time, and yeah. Thank you.
Go ahead, Rohan.
Thank you so much. I actually have two quick questions. I guess with regards to the cases against Bill 5 and Bill C5, I guess one of my concerns, is that Bill C5 repeatedly references, Indigenous consultations and climate change and clean growth, whereas the provincial Bill 5 has barely any mention of any of these, with other than a couple of references to archaeology and community knowledge. So how do those major differences factor in your submissions? And
Let's let Alex start with that one.
Okay. Yeah, so I think, yes, there's a lot of repeated references to Indigenous consultation throughout the Building Canada Act, but still, I think there's no requirements for Indigenous consent, so that's still a major problem with the Act, and I think, yeah, I don't know that, the different references to Indigenous consultation, super factored into my arguments, I would say, because of that. I do think, given, the federal government's repeated statements that Indigenous consultation is important and we need to have Indigenous partners on these projects and proponents, I think that just affirms the need for consent, because if the federal government is uplifting some voices, Indigenous voices that are supportive of projects, but then sort of ignoring the ones that disagree, then that comes across as a bit disingenuous, I would say. So yeah, I think I just focused on making arguments that recognize that not every Indigenous community does consent, and we need to uplift those voices and listen to them. In terms of climate change, it's I don't know if the factors are listed in terms of importance. The interest of Indigenous peoples is D, and then contribute to clean growth and meeting Canada's objectives is E. I don't know. I kind of feel like they might be, but I don't know how much that factor necessarily matters to the federal government, especially given some of the developments and getting rid of some of the legislative and policies that advance climate don't advance that deal with addressing climate change. But yeah, I think either way, the Ring of Fire projects aren't necessarily suitable for addressing climate change because of the peatland. So I don't know, sorry for that convoluted answer.
Anyone else have a question? For anybody? You guys are quiet today. Jalissa.
I had a question for you, Will, actually. Okay. You talked a lot about how the minister is going to have discretion under this legislation. And I'm sorry if I missed this, but is there any requirement or sort of like explicit or implicit that the minister has to be reasonable in interpreting things like whether a company has historically abided by environmental protections? Like, do you think that there is that requirement and that would allow us to maybe review decisions of the minister that stray a little bit too far from those factors?
I think based on the language that's used in the statute, it's most of the time it's, you know, in the opinion of. And so I think that that leaves just like the widest possible discretion for the minister to have that opinion. And so I believe that like it's just like a review of that decision would just be like, it's not like we can challenge it as not being kind of like a reasonable belief, because that's not what is required of the minister for the designation. And so I think that's just one of the main problems with the designation criteria in the first place, is that it basically just creates almost unreviewable decisions for designating these projects and these proponents. Yeah.
Daniel.
Just curious, for the fifth year, you all mentioned your suppliers, what was the second comment that the minister can send projects from large number of provinces and a large number of states as well. Now my question is if any of those statutes have a provision that the minister can send a project to the requirements in that specific statute.
That's a good question. I haven't thought of that.
Me neither.
To look into.
It's a good question,
But
yeah.
some of you were looking at the Fisheries Act authorizations. Who was that again?
Henry?
Was that you, Henry?
Yeah.
So Daniel's question is like, if these statutes have this overarching ability to identify statutes that will be waived, I think you're asking, did any of those statutes already have provisions within them that could be waived?
Well, I wrote more than so you have, but it looks like in practice, most of the federal statutes have in fact orders, whether either through discretion or through sort of like internal policy documents that just pass over the part of official authorization, and those policy documents cannot be reviewed judicially.
Yeah, it's reminding me of the MPP Saul Mamakwa on Monday at the press conference that Neskantaga was doing, was saying about Bill 5 in special economic zones, like Premier Ford has this hammer, right? Is he going to use it right now? As people have said, he hasn't repealed it, so he's still holding that hammer. But like you guys are saying, the SEZ Act is another one. You know, whether or not there were still powers like that available, there at least sometimes in the past has been like political accountability in respect of picking up the hammer, right? And so I think that's in some ways what we need to get back to, like actual consequences for politicians who take extreme measures to overcome opposition, right? And to undermine democratic rights and rights of self-determination and the kinds of things folks have been talking about here. Any other questions? Henry, and then we'll do Ron.
This question is for Alex, just because I thought it was really interesting that you went into the climate harms. But I was wondering, is anyone trying to bring any kind of legal action based on that specifically? Because it seems like even if you ignore all consultation issues, this is still an insane project just for that.
I don't know. It's definitely interesting. I mean, I feel like the climate change lawsuits have been a mixed bag in terms of success. And of course, we're like still waiting to hear about how those are all going to go. But it's an interesting idea. I don't know of any. I haven't heard of any. Do you? No. Maybe something to talk to West Coast about. I don't know.
Hey, Rohan?
I guess my question, kind of relates, the second thing you're talking about is, how we approach, mining, and how mining is used, because like the fossil fuel industry is pushing out a lot of propaganda that, you know, we don't need clean energy, you know, we can survive on oil and gas forever, you know, we're gonna need it for a long time. And I guess my fear is that if we take, and I'm against the fire, but if we don't take just a nuanced approach to mining, we then fail to build up clean energy supply. We then face some of the worst economic growth in the G7, and then because we just don't have enough clean energy supply, because there's no such thing as perfect technology, and then we ignore the legitimate security and defense capabilities we're saying right now, and the need to essentially scale up. I guess I want to see, like, what do you see the balance if we do also the problem of building things in Canada as well?
I can try and address some of the concern. I just think the main thing that we're focused on is that the Ring of Fire, even from like the concerns of addressing like a green transition to clean energy, the Ring of Fire is not the ideal place for these resources to be sourced from. And I'm not gonna give my approval to any other locations from where to grab them, but I think that especially here where it's just such intense opposition to development in this region, this isn't the place where we're going to address these issues of the green transition. And it's important that these decisions be done with securing the full, with securing the full consent of relevant Indigenous nations. And so, yeah, I don't know if there's any other points on that you guys want to grab.
Yeah. I completely agree. Yeah, I don't necessarily know if I should say, oh, maybe not the Ring of Fire, but here would be better. But the Ring of Fire isn't the only place that you can mine in Canada. And I think, securing Indigenous consent is essential. And also, yes, like I mentioned, in terms of the green transition, like mining, extracting mines and building all the infrastructure needed to extract critical minerals from the Ring of Fire, and disturbing the Hudson Bay lowlands is just not a good idea from a climate perspective. And they're very sensitive ecosystems, so even just a little bit of disturbance could impact the health of the peatlands and their ability to store carbons pretty extensively. It's just a very risky thing to do, and there hasn't been much, or I would say enough, research about how the peatlands might be impacted. So especially through these fast tracking processes, it just doesn't make sense.
Can I make one small comment on that, and then I'm going to come to you? I saw recently Thea Riafrancos came to Toronto and talked about her book Extraction Capitalism on the Green Frontiers or something like that. And it's an excellent book, and what Riafrancos does is she also, like you, Rohan, is not willing to say there will be no mining in the energy transition. But she does really point out that we have to be super focused on investigating the assumptions that back those projections of demand, right? So where is this projected demand coming from? Who's making those projections, and whose interests, et cetera, right? So, for example, we noticed a couple days ago a guy who heads a mining company that does some exploration in Northern Ontario had an op-ed published in the Hill Times where he was talking about, this demand for minerals and how we really need to get exploration going to meet this demand, explicitly mentioning the conflicts that are increasing around the world and the uses of these critical minerals in defense applications, and weapons and armored vehicles, et cetera. So here's a person who will personally, financially benefit from projecting that demand to be more than it might be, right? And that's rampant. That is rampant. So Riafrancos is also part of the Climate and Community Network, I think they call it, which produced reports questioning, for example, whether or not the demand projections for electric vehicle batteries, the minerals needed for electric vehicle batteries, are based on the replacement of every single combustion engine with an private electric vehicle, right? When they could be based on things like, okay, how do we increase people's mobility, right? And do we need electric vehicle batteries for public transportation? Then yeah, we can take those kinds of projections seriously. But we shouldn't listen to the people who want to sell electric vehicles about how much minerals we need for the green energy transition, right? So to me, that's a really important way of trying to get at some of those assumptions. Any other questions? Or I see our lunch is here, so maybe we break for lunch now. We're going to try and put our land defenders up on the panel. I know many of you are waiting anxiously for that part a little bit sooner because they do have a hard end at 2 p.m. Okay, everyone, thanks for coming back. I'm not going to say much here, just to introduce the fierce panel of land defenders and allies you have in front of you. Nessie Nankivell is a PhD student in the Department of Geography at U of T. Wayne Moonias is the Lands and Resources Manager at Neskantaga First Nation and a former chief of the community. Colleen Moonias is a current councillor of Neskantaga First Nation. Ramon, Kataquapit, and Jeronimo Kataquapit are land defenders from Attawapiskat First Nation. And Eve Saint is the co-founder of 8th Fire Rising. Each of them will probably say more, I'm sure, to introduce themselves, but I just want to have you welcome them up here. I'm not going to take up any more of their time, and we're going to hear about some of the land defense actions that have been taking place, not only in Treaty 9, but across the country.
Well, I can kick us off. Hi, I'm Nessie, and I have been working with Neskantaga First Nation for 3 years now, almost 4 years now. And I'm going to introduce Wayne and Colleen, who are going to be talking about what Neskantaga has been up against during these past 2 years of Ring of Fire development. Maybe Colleen can give a little context about the community and what the community's been facing, and then maybe Wayne can talk about the encampment and the work we've been doing on the river. Sound good? Or whatever you want to talk about.
Hello. Hello. Bonjour. First of all, thank you for you all being here today, and thank you to all the presenters. I think you did a really good job in explaining what's been going on, and it's very much appreciated. Also like to acknowledge the lands where we are. Where the Mississauga have the credit in Anishinaabe. My name is Colleen, First Nation Council for Neskantaga First Nation. This is my second term as a council member. And some of the things that we've been challenged, or we've been experiencing in the community is we have ongoing issues with our health care, with our infrastructure, and as you all may know, our ongoing boil water advisory, which has come to 31 years as of today. And those are real challenges that we face as a community. It deeply impacts our way of life, our rights as human beings, and continuously, exhaustingly, we've been advocating for our community. This, as leaders go by, as leaders from the past till now. And it's pretty exhausting how we are treated by the government, provincially, federally. So that's the challenges we face, and those are very serious challenges that cannot express how very saddening or very frustrating it can be. And nonetheless, you know, our community is very tied into their way of life, like fishing, hunting, enjoying their bush tea, making tea banas in the out there. It could be around the surrounding waters or the surrounding road areas. You know, we practice our hunting or traditional areas daily, seasonally. You know, it's very good up there. Nessie has been up there too, and also Dayna. You know, they experienced it, and I think they do enjoy being up there. It's very a good place to be if you wanna consider doing some healing on the land with the fresh waters and going fishing. It's very peaceful and comforting. So you know, just let you know, if you really want to come up there, let us know, right? You know, we do welcome people who, you know, are respected, will respect our ways of life and our community. So I just wanted to say some things about my community, you know, with the challenges we continue to face, and also our value to our culture and our traditional practices are very much valuable. So with that, I'll get the former Chief Wayne here to speak on other stuff. Miigwech.
Okay, Miigwech. My name is Wayne from Neskantaga. My traditional name is Attawapiskat Indigenous. My Hingan is my do with them. So we just wanted to share some of what we're doing in our First Nation. As you know, the Ring of Fire, the proposed road developments and mining development that the Ford or the other governments or industry wants to do. You heard our position as a community. You've seen it. You've seen it on media. You've seen everything that is representative of why we're doing this. It's a representation to our people, and that's one of the biggest things that our resiliency is still here. We're so resilient despite all the crises and social emergencies that we've faced in the community. Colleen and the council work tirelessly in our community to try to always attend to these things, but yet our community is still resilient and still deeply connected with our homelands. All the gifts and the medicines that are on our lands is very critical and very important for us. So that is the reasoning behind our position, because it's not just about jobs. Premier Ford talks about bringing in benefits, bringing in the quality of life of your communities are going to improve. But we hear that even the road access communities that are in our tribal council area, some of those conditions still exist. And I think that this is the reason why we're so ingrained and connected and deeply connected and cherish our lands and resources, because that's where our healing, like Colleen said, this is where our wellness comes. We know where our medicines are. We know where the sturgeon, where to set up the fish net if we were to harvest some sturgeon. We know where the walleyes. We know how the moose are and all those things. Our people know that. Our people are connected to the land in ways that we cannot describe fully, but it is through their actions that our position exists. Nessie sharing some photos, a representation of our people, basically the things we do, some of the things we do on our land. And this is what is at heart when we're talking about protecting the way of life of our people. We know that how important the river is. We know the proposed crossing of the community, of the proposed Northern Road Link. What's it going to do on our river if that happens? And that's why we have said that we are prepared to stand in front of those bulldozers if they want to cross our river system, and that's the position of our community. As well as the encampment, we've been very fortunate enough to get the support from Attawapiskat and other nations that have come to us to join with us, stand with us. Jeronimo is here. I was very fortunate enough to go down to the river during the summer months for over a week with my 9-year-old granddaughter. We stayed there for over a week. We had Nessie and Omar that came, and Dayna and Isaac came afterwards. So we did that, and a lot of our people are still planning to go there, and a lot of our people went there this past summer to just show their solidarity. And this is what is needed. We need help and support and to stand with us. I think this is one of my messages to you all there. If you're able to help in any way, whatever help you can provide to First Nations like ours that are standing up for our rights, standing up for Mother Nature, standing up for the creations and the medicines and the sturgeons and the caribou and all that, everything that's on the land that lives there, and we need to make sure that we carry their voices. And that's basically what our elders have told us, to always never forget why we are here today as Anishinaabe people. It's from the creations. It's from our creation stories, and we need to be one with those creations that we have on our land. We know where our medicines are. We know where the water life is. We know where our sacred and burial sites are located on that river. It's right throughout the river system. So if they say we're going to cross this and there's nothing there, it's not only just going to impact that area, it's going to impact the whole system. And because that's why our community considers our Anishinaabe connections to be holistic. They're all interrelated and interconnected. And that's what the Ford government and the industry fails to understand. They think that we'll destroy a certain area or we'll disturb a certain area. If you disturb that area, you're going to disturb the other areas of our homelands, and that's what the community will not stand for that. And I think this is very important. We had some of our land defenders on Sunday when we held our rally. We had a couple good speakers from our community. One of them is here, Darren. He spoke on our behalf just to reaffirm the position of our community, why our voices matter. And we had Lawrence Sackney that also came, a land defender, a land user. He has his family, his kids, and his family is deeply connected to, like all of us, to all areas. So we're here today just to basically share, and hopefully if we have an opportunity to answer some questions, we'll do that. But some of the pictures that you see here, it tells a story. It hopefully gives you an insight into why we do what we do, why we say what we say, and why we take the position of what we're trying to do. Because that river system is our life. It's not just for today, but for tomorrow. So at the crossing this summer, like I said, we had Nessie and Omar that came in. And we were able, because the water was low, we were able to bathe and have a nice swim. I'm only 5'6", 5'7". For once, I was able to say that I can stand in the middle of the river with half of my body in and half my body out. So I felt so tall. But our elder Tony was our driver. Tony Sackney, he's in those pictures too. He took us on that river there, and all of a sudden Tony says, "I'm going for a swim." It was like 40 Celsius that day. The wind wasn't that great. It was really hot, a lot of humidity. And then he just went in. And then next thing I know, Omar goes in. Next thing I know, I see Nessie wanting to take a swim, and I just said, "I'm going to go swimming." So that's what we did. But our good friend there, Dayna, is another story. She doesn't like porridge with chicken noodles, so that's all I can say. Still haven't stopped bugging her on that. That is one of our family, our community recipes. Porridge with chicken noodle. I don't know if anybody has ever had that, but Omar, Nessie, and Isaac loved it. The only one that didn't like it was our good friend Dayna. But we did have a lot of laughter, and that's part of who we are as Anishinaabe people. We're able to laugh things, and we're able to enjoy and express despite the strong positions, strong words that come out of our mouth sometimes, and the positions we take. We also have, laughter is good for us, and it's about healing, and it's about being one with the land. So I'll leave it at that, and hopefully if I have an opportunity to answer some of your questions on some of the things we're doing, and then miigwech kitnagom gakana. Miigwech.
Before we wrap up the Neskantaga portion of the panel, I'm going to show you some of the, very, very quickly, some of the work we were doing on the river last summer. Me and Omar, infamous Omar, is my colleague from the UK, from a human rights research agency called Forensic Architecture, and Neskantaga and Osgoode and the clinic here and Forensic Architecture have made this research collaboration. And so when Wayne talks about how Neskanaga's view of their relationships and their view of the river is holistic. It's not what Ontario is trying to say, that you can build a road here to avoid certain cultural areas at another site. That just doesn't align with Anishinaabe law and the understanding of jurisdiction as being the sort of entire length of a river, and that you can't fragment or fracture that river system. So what we're trying to do, and like Skye's research on burial grounds and like on sort of Ontario's law around these things, along with our time on the river, helped us come up with this. We're trying to develop a new mapping technique, a new way of mapping land use and jurisdiction that takes this holistic approach that's more based on how do we visualize and map relationships rather than static points. So how do we move away from having protections on static sites, this sort of like colonial mapping idea of like fixed coordinate points, and move that more towards mapping relationships, which show how damage done in one part of an environment, has much more dynamic effects. So we spent, this was an interview we were doing with just one land user, but we were out in the summer. This is Joe Yellowhead. He was a very accomplished hunter, and so we spoke with everybody who was at the camp. Everybody got interviewed, and we asked them about the types of things they would look for when building a campsite, because as we've learned in Neskantaga.
You're not going to share my Rambo t-shirt?
No, I will. Actually, your Rambo t-shirt was already in the slideshow, actually. We know that Ontario can't develop land where there are human remains. We've learned from Neskantaga that traditionally the death and dying practices in the community are that you get buried at the campsite where you die. Because up until very, very recently, when the community was forced onto reserve, before that, people lived up and down the river seasonally and socially. So we tried to build this like legal argument and mapping technique that could identify anywhere on the river that has the characteristics of a good campsite. You could make an argument that, given that they've lived on the river since time immemorial, that site probably has been used as a campsite, and so could feasibly have human remains in it, because that's where people would bury their loved ones. So we did all these interviews, and we came home and we had all of these maps and all of these interviews and like hand-drawn maps we had done in the field. We did interviews in canoes and by campfires, and we digitized all this data, and from all the interviews we extracted every piece of like spatial or environmental criteria about each type of relationship. So your relationship towards shallow parts of the river have to do not just with the depth of the water, but it's like inherently tied up with your relationship with sturgeon, because that's where sturgeon spawn. Or elevated parts of the riverbank are places where you would build your campsites. We extracted all of these criteria and then figured out a way to map or visualize each of them. So we learned campsites need to be on high ground, dry ground, need to be close to certain types of trees. So we use remote sensing to make a map of soil moisture. So this shows where the soil is dry enough to build a campsite. We ran analysis on satellite imagery to figure out what types of species of trees are where. So this shows where trees that are good for firewood are. And as we made each one of these mapping layers, we then layered those layers on top of each other to make a probability map of where it's most likely that a campsite could be in the future or where it was in the past. So trying to move away from like traditional land use mapping right now, which is very much based on like what is there today? Where do you guys go today? Because that's also, land use today is already distorted by colonial violence and is arbitrary. Today is arbitrary compared to the land use before and the land use in the future. So we map all of these layers on top of each other, and we're almost, it's almost ready to be published through Forensic Architecture. This is our latest draft we're gonna make a map of the entire Attawapiskat River to show that any place that's sort of feasible to build a road also shows up on our heat map of where is the most likely to have been a campsite and where Neskantaga and Attawapiskat have like full rights under Korean and Anishinaabe law to preserve those lands because they're useful, not just today but for future generations. So that's what we've been working on. So, yeah.
I got a little story there about Isaac there. Isaac was our camera guy. We did the way we wanted to communicate with the social media or with our members back home was we did Facebook Live little casts. We did I think in the morning, in the afternoon, in the evening. So it was hard towards the end of the night because everybody was tired. But we committed ourselves to do that. So this one evening, Joe Yellowhead and Lawrence asks me there, we got to do one for before bed. So I wasn't even, I was in my shorts already, and I had this T-shirt on, this Rambo T-shirt, First Blood, that T-shirt there, and then I had this red shorts, I think, and then I put on my rubbers. My rubbers was like hitting the knees, and sure enough, I got into the. Normally, I tell our people that are gonna film us, just do it this. So I guess what Isaac did is he expanded it and he showed me the whole body. All my kids are messaging me after during the Facebook Live and after. Geez, Dad, you look so cute. Why are you dressed like that? So that's why I was asking her. You're not gonna show my Rambo T-shirt picture? Okay, be good.
Is it just an introduction or?
If anything you'd like to, if you guys want to share, introduce yourselves, of course, and then maybe the work you've been doing with organizing youth or what you've done at PDAC this week.
Okay.
Anything you want, and I'll put your stuff first.
Oh, is this thing come out? Wache. Okay, it works. Wache, Ramon, Kataquapit, Nijnakasun, Attawapiskat, Dostrin, Mixototem. Hello, I'm Ramon Kataquapit. I'm from Attawapiskat First Nation, and I'm a part of the Eagle Clan. And today, I'm representing Okinawak. It's a youth-led movement founded in response to Bill 5, but it's been something that's been brewing for a long time. When Bill 5 passed, I'm a youth council member with Anishinaabe Nation and Chiefs of Ontario, so I was able to come with the leadership into Queen's Park, the legislator, to watch the bill pass. And I've seen a lot of my leadership in these rooms, and they're with us in the gallery. And we also watch Sol advocate for us down there, Sol Mamakwa from the NDP. And I seen just how they treated the voices of the First Nations people, or the leadership that I respected the most and that I looked up to and that I trusted would get things done for me. And just the way that it was bulldozed over with them given like 7 minutes at committee hearings and not even discussed with before when the bill was in making. So not even given that actual free, prior, informed consent, it's not even in the bill. And I seen it pass. And I watched the leadership and I watched the faces of my leadership drop, kind of like that pen there. And I felt my heart drop too, because I knew what that meant for my people. I knew what that meant for my community. I knew what it meant for the precedent that's going to set, where this bill has the powers to designate a special economic zone that can overwrite environmental regulations, provincial regulations, and even our treaty jurisdiction. And I felt something in me click. And the leadership, they had a media response right after the bill passed in the legislature. They said, you're gonna see us on the ground. They said, you're gonna see us fight against this. But they made their quotes and then they left. There was a delegation of people that were still outside, of our people from all over the region, that were waiting for them outside for support. And you know who stayed after the leadership left? It's our women, our youth, and our two-spirit plus kin. They were out there and they were ready. And within days, mobilization happened everywhere. With Jeronimo, with Here We Stand, a youth group in Timmins, Youth Rising Together, and even us shortly after came to being, of creating these movements and where we were at to mobilize not only our people, our youth, but ourselves. Because we knew that we couldn't rely on our leadership anymore to make these decisions. Not that they're not good leaders, but that they've had a good race, they had a good journey. A lot of them have been in leadership for longer than I've been alive. They're tired, they're scarred, and they've been boxed in by legislation, policy. They've been boxed in from the government, where they hold leverage over them and say, if you don't conform, funding will be pulled, opportunities will be pulled, economic development will be pulled. And it's held as leverage above our heads, like a carrot on a stick, which keeps our chiefs from being able to be who they are and why they came in these positions, but just adds to the point of why the youth decided to represent ourselves. So with these movements that came to life all over, Okinawak was born outside of the Queen's Park Legislature around a sacred fire. And it came with this vision of uniting youth, not only in our region, not only in the province, but across the nation, so that we can stand together and unite against things that are harmful towards First Nations people in our future, so that we can have equity, equality, and environmental stewardship. And because we're so sick of seeing our people get put in boxes, we know just how much the land means to us. And I want to explain more on love. And that's something that has come to my mind the last few days I've been here with Jeronimo and being at PDAC is love. They're not leading with love with this bill, with the way that they're only including 2 communities for impact assessments when it affects the whole of the region up there. Or with the way that they're holding leverage over us. Or with the past press conference with Ford saying that this is for economic opportunities for especially your youth in your First Nations communities. This is for training, this is for education. We're gonna develop so much up there, leave your excavators up there. But you know what, the work that we've done with Okinawak? We mobilized thousands of youth since last summer. We've held our first major rally in Queen's Park. We held our second rally at Parliament Hill, and we took a delegation with youth. Jeronimo was there, and we went to the Canadian Museum of History, where the Prime Minister was meeting the chiefs. And we decided to go represent ourselves and to go demand to be let in, to speak for ourselves. Because we've seen that this messaging is becoming so political with having economic development over our heads and this idea of prosperity being economic development only, when the messaging that's shared from these thousands of youth, from our families, from our communities, is prosperity of making sure that we're stewarding and keeping safe what was entrusted to us through love. Because we love that land and the land loves us. That's why we were born. That's why we came onto this earth, is because of love. But also because of a duty that we have been passed down generation by generation. You know, that's why I carry this stick. It's a staff that represents my treaty with Creator, our treaty with Creator. Because it comes from nature itself. And we lead with these things. This is a part of what we want to protect, is our identity, because we are one with the land. When we take care of it, we take care of ourselves. That's what I've seen a lot of the youth that haven't been in these positions, that haven't been influenced by political wording or any kind of chiefs or organizations. That's what's inherent to them, of wanting to protect where their home is. Which is so important, why we've been mobilizing the youth everywhere we went. After Parliament Hill, we mobilized in Moose Cree, North Bay, Metagami First Nation, Kingston, Queen's Park again. And we're gonna start doing more mobilization soon with rallies. But between that time, we switched over to more safer environments by holding panel discussions like this, or holding Q&A talk sessions in Toronto. But we also included things where we had a benefit concert in Kingston, where in between the talks like this, you had someone performing. You know, just to keep that energy light, because not everything has to be heavy when it's shared about what's going on in our treaty territory. And you know, it was a good experience. So we've been doing things like that. And alongside that, I think we're making headway as grassroots movements by working together with political governmental organizations. We got acknowledged and were formally supported through resolution with Chiefs of Ontario, Anishinaabe Nation, and Jeronimo with Mishkegawak, and Jeronimo with Here We Stand is also recognized on all levels to the provincial. And next it will be national at AFN. But also with Okinawa, we are working with land, legal advocates for nature's defense. And I'm a part of a court case as an intervener of bringing the Ontario government to court over the constitutional rights that are being infringed upon for our treaty. So we're hitting it at all different angles. Not only are we on the ground down here, but we're also with our First Nations governance, but we're also doing it through the legal court system. So that we have many approaches towards bringing that advocacy and that message out and making sure youth voices are in these spaces. Because a lot of the times it's tokenism. A lot of the times our youth are just put up there for show, but we know how much they know and how much they feel for these topics at hand when it comes to their future. I feel like I'm talking a little too long, so I'll wrap up here. With Okinawa, we've been mobilizing youth so that we can speak with each other, for each other, to the world, giving each other a platform, especially when it comes to our home. The Ring of Fire, it's the breathing lands. And I'm sure many of you know about the environmental impacts that you have disturbing these lands, but also sharing with you just now about the spiritual and social impacts that this has, and that the precedent it will carry for whether or not our identity will continue to remain strong, or if assimilation comes stronger for our people. You know, I'm a part of that first generation outside of this assimilation tactics with my grandparents that went to St. Anne's residential school, with my mother that went to Indian day school and boarding home. And we're part of that first generation that's able to make those choices that, you know, our parents didn't have, our grandparents, and even further back. So there's a lot of weight on our shoulders to be able to stand for ourselves, but there's also a lot of strength behind it, because I know that our ancestors are with us. They're putting us in places where I never thought possible, but also the future generations that are waiting for us to go and walk that path. And I think that's something that's truly special with this young generation, if you want to call it the seventh fire prophecy, or just the youth of today. And yeah, miigwech.
I'll let you know when. Wache Miswe, can you hear me? Can you hear me all right? Okay. Wache Miswe, Jeronimo Kataquapit Indigenous Cassin, Attawapiskat My name is Jeronimo Kataquapit. I live in the community of Attawapiskat First Nation. My traditional name is Gamachachuk Mishtettim, which translates to running horse. You know, I'm sitting here, and it's funny, as Wayne was telling the story, looking like Rambo on the river. I remember that moment. Like, I was doing a live stream too when I came. I'm like, oh, I'm done mine. I'm like, is he live wearing, looking like that? And all these other stories that Wayne was just telling about Dayna with the chicken noodle and the rice soup. My parents made some of those as well. And it's just brought all these good memories of our time on the Attawapiskat River from June all the way to the end of October or into November. I'm the founder of the movement, Here We Stand, and it was established in response to Bill 5 and Bill C5 as well, when it was still called early on the national interest legislation. And I traveled around 600 kilometers up the Attawapiskat River from Attawapiskat First Nation with my parents. It's a fully grassroots-led movement. And how that came to be was I told my parents, we've been talking about the Ring of Fire for a while. My parents have actually been up to the Ring of Fire before, back in 2018, 2017, to go plant community flags from the First Nations on the James Bay coast at these locations. And so it's something that we're very familiar with. And I told my parents when I first heard of when the Privy Council first sent out their letter to the chiefs, and I was at I was in Sault Ste. Marie with Attawapiskat First Nation as the youth delegate. When I first heard of Bill C5, I told them, Mom, Dad, we need to do something. We can't wait around for our band council to go ahead and start talking, to start representing our people, our community, our home. And so I'm also a university student. I go to the University of Waterloo. I'm 21 years old, and I take geography and environmental management with a specialization in GIS. And so when we started this journey, we didn't have too much support, so I just started reaching out to everyone I can, Mushkewa Council, our leadership, others, and eventually Neskantaga First Nation. We never had any communication with the community before this. And so I thought, you know what, I'm gonna do something our leadership keeps putting off, and to establish contact. So it's funny, I used Facebook Messenger. It's a big thing up north for some reason. And I messaged the former chief, Christopher Moonias, on Facebook at 1 a.m. when I was in Quebec, Kataquapit. I was there for training on polar bear monitoring, and I was like getting things ready for our travel up the river. And he responded to me at like 1:30 in the morning, and he was like, "Okay, sounds good. Let's talk more tomorrow." Then after that, we set things up, and our relationship with Neskantaga began there shortly after. And before I get started with anything more, I wanted to play this video here in a minute, just to show you what my homelands look like, where I'm from, my people, the Cree people. I grew up on the lands all of my life, the waters of James Bay, as far up the Attawapiskat River as where the main Attawapiskat River meets the Makati River, if any of you know where that is. I've been essentially almost all over the coast, and my first time out on the land was when I was 4 months old. My parents went out like 300 kilometers north of Attawapiskat in -30, and I was in a Tikanagan, and my mom cared to me when I was inside the tent, while my dad and my uncles went out to go hunt the caribou. So I've always been going out to the land since I was like this small, and I continue to do that. And you know, one thing that I've been told my whole life, Jeronimo, everything you need is right in front of you. And I was always told that by my elders and my family. And I originally never wanted to go to university because I thought everything I need is here. My people, my home, my history, who I am. Then with everything regarding during the fire, my elders, my parents, my community told me, go to school. Use that education, combine it with ours to protect our home, to protect who we are, to protect our livelihood. And I remember my first time being on a big plane, bigger than a Dash 8-100. If any of you know what that is, 2.5 years ago, coming down to Toronto, I was like, where am I? It's funny because at Waterloo, I took Ubers only for 1.5 years because I was so scared of public transportation. I know how crazy that sounds, but it's very different from where I come from and where I'm from. And so you can tell I'm also a videographer, and I made this video 2 years ago with drone videography of just the marine coast of James Bay. And this is just one section, a very small section of my home and where we come from. So I want to go ahead and play that before anything else. You know, one thing you often hear is why is Attawapiskat so concerned about the Ring of Fire? And one thing that comes to mind immediately is that one thing my grandparents, my great-grandparents, and my parents have always said is that all water flows down. It all goes somewhere. Whatever happens upriver happens to us. And in the first 10, 20 seconds of the video, you actually see the mouth of the Attawapiskat River that flows out to the James Bay. And, you know, with everything that's coming, I've heard many different people and refer to the area as all these different things, but the first thing that comes to mind when I talk about this area is that it's home. And it's home. And there's a certain responsibility that comes when that comes with the that's passed down from generation to generation, from my grandparents to my parents, and now us. And that's to protect the land, to protect the water for the future generations at all times. That the land isn't given to us by our parents, but it's loaned to us by our children. And that really puts into perspective our way of thinking. And this video is just from a 4-week trip I took out to the bush here by canoe, along between Attawapiskat and Cape Henrietta Maria. And it just really shows a really small portion of the diversity of the entire Mushkegowuk homelands and the Mushkegowuk region that extends from Attawapiskat as far upriver as Neskantaga. And many of the things that, you know, I'm hearing talks about what's you know, why is Attawapiskat involved with, why are they so concerned? And many of our ancestors are buried all along the Attawapiskat River and as far up the Makati River as well. Many people don't know that there's hundreds of grave sites along these sections. Even as it goes around but you know, as far as what I do, I'm kind of like the official delegate for Attawapiskat at all times with the chief and council. I'm always out here doing things on the behalf of the council while keeping kind of at a grassroots level with all of the work that I do. And so we spent how long is it, 5 or 6 months on the Attawapiskat River with my parents and some other community members that I brought from Attawapiskat. Unfortunately for me, I have a tumor in my throat and I'm very sick, and it has been infected throughout these last couple of months, so I had to leave the camp early in August and spend a lot of my time at the hospital and ER in Timmins getting CT scans, and I ended up losing a lot of weight and ran into some health issues. So I was, but in spite of that, they kept the camp going and everything else as that happened on the river. And here I am now, once again. I'm finally getting slightly better, and I have surgery relatively soon. And in spite of everything that's happening to me, I recognize the importance of what needs to happen on the river in this next little while. I spent a lot of time, I guess you could say, gaining support from the different First Nations in our region, the Mushkegowuk region. So there's actually resolutions passed by Mushkegowuk Council that declares the entire region where the Ring of Fire is as a protected homeland, and all of the people at the camp, land defenders as well. And there are other First Nations and environmental organizations such as Sierra Club, Greenpeace, David Suzuki, that want to collaborate with us on the camp. And like I said, it's kind of became less of a camp and more of a community with our time on the river. And it started off with us really raising awareness to show our presence and to bring, you know, that really grounded worldview to the region, because more often than not, and the longer I'm in Toronto, the more I find out of just how much there is a really strong narrative here regarding the Ring of Fire region, along with the ads, because I've never seen a Ring of Fire ad before. it's funny because I spend so much time out on the land. I have a completely different view of it than when I'm here. They're talking about it, and there's a lot of I guess stock footage of completely different areas across the planet, rather than the region itself. And yeah. So what I do, what I'm doing right now is gaining, still bringing together that support from the communities along the coast. And right now, there's other First Nations, such as Fort Albany, even Keshkatchewan and Moose Cree, that want to join the camp, that want to join our community. And that requires a lot of, for us to be on the river. And I'm at a point in my health where I have to choose which one I want to prioritize. And so with everything out there, the land, the water, everything that makes us who we are comes from the land. Our history, the language, the stories, the culture, all of it. And to us, it's everything. Everything we were, everything we are, and everything we will be. And this region is important just not to our people, but to people all across the world, for as many of you are very knowledgeable in that regard as to the importance of the peatlands themselves and what it offers the world. My community goes through a lot of issues, from housing to drug epidemics to suicide crises. Attawapiskat has been on the news many, many, many times in the past 2 decades. And in spite of all of that, I'm so proud to be able to go out on the land, how fortunate I am to see the things that I do when I'm out there all the time. Prior to making this video, I had a certain worldview about the land, where I would finish school, hop on my canoe, go out with the tide, the beluga whales would come in, the seals would come in, feed on the whitefish, and maybe if you're lucky, you would see a polar bear out on the river. Or we would go upriver and see a herd of caribou, some moose. Maybe you would see a sturgeon in some of the shallow parts just swimming there, stationary. And I thought everyone in the world did that, like the Prime Minister himself too, just went on to a boat after school and just went out for 2 weeks. And what we have here is very special. And with everything that's coming into the region, there's no more important time to stand together than now, both as Indigenous people and non-Indigenous people, as grassroots people and through non-grassroots people, whatever that may be, whatever that may look like, because this affects all of us. Neskantaga means every single person around us. And so I'm probably talking a bit too long again. The Attawapiskat table likes to talk. And just I guess one thing I want to touch on with everything happening on the river, we have many grave sites and other locations as well that we haven't necessarily combined with Neskantaga First Nations yet, and it's all of the grave sites all along the Attawapiskat River and into the Makati River that many people don't know about just quite yet, and a lot of our territories around this region do overlap, and that's just something that I want to acknowledge, because a lot of these borders on the map and jurisdictions are a colonial thing, not a true Indigenous pre-colonial thing. And my obligations to the land, to the water, to our home, all of us here, isn't restricted by the border of my reserves. It expands beyond that. And our relationship with Neskantaga throughout the summer has really shown that we're all in this together, that this affects all of our futures, wherever we are. And this is the path we walk, the one we'll walk for the next 100 years. The precedent set by the Ring of Fire and the region, and Bill 5, Bill C5, will echo, just not here in Canada, but throughout the entire world, because we're talking about a massive area that's a very delicate ecosystem and pristine and intact. It's home. And whatever happens next, whether it's for us or against us, will set the tone for other projects such as these for the rest of Canada, for the rest of the world. And throughout the summer, we've just been on the river. We haven't done too many stances against this and that. And already we have, at least on my end, I was telling these guys of how Wilo keeps wanting to come into the camp. The CEO actually wants to come to the camp to do a podcast, which is I guess they keep up with the live streams that we do on the river, and they're trying to accommodate us in a way, but and the federal government as well, the ministers have wanted to hear our concerns regarding what's our problems with Bill C-5, and so we definitely have their attention, and they do not like mentioning us anywhere. And the provincial government as well, yesterday, what was that, 2-3 days ago, we were at the press conference at Queen's Park, and Neskantaga here invited us. Doug Ford just happened to be walking by on the upper levels, and he didn't realize he was being recorded, and looked down as these guys were walking into their press conference, so they're fully aware of what's happening on the river. Anyways, so I'm talking too long. I'll go ahead and end it there. And I just wanted to thank everyone for listening to me, and hope all of you have the rest nice of your day. English.
One minute, okay. Hello, hi, Wiche, Annie. Thank you so much, everyone. Wow, I don't know how I can follow that. My name is Eve. I am a Wet'suwet'en land defender. I'm also Mishkegawuk too. My mother's family is from Attawapiskat. I am second generation Torontonian. My grandmother came down to Toronto after she went to St. Anne's too as well. And I kind of consider myself a little bit of an outcast. I feel like I kind of don't belong anywhere. Growing up in the city, I was always the Indigenous person in school. I finally was able to go to Attawapiskat, but I didn't grow up in the community, so I was a little bit of an outsider. Even out west, when I went back home, even though I look very West Coast, which I didn't know until I went there, and being from Toronto, so I think that kind of gave me a sense of being an underdog. And wanting to fight for the underdog, and wanting to include everyone, and because I kind of know how that feels. And just wanted to say, being a land defender, we don't get to really have a choice. I wish I could just be a mother. I can't. And the way my journey started, it kind of got reignited by Standing Rock. And before that, I was also like a Ashkabewis. I would help medicine people, healers, and seers. And I think that's where that need to protect, stand up for the land comes from. And then also being in ceremony, you would hear some messages from our ancestors of what's to come. So I think that kind of gave me an extra urgency. Also, on this journey, this path, I've always kind of, I have a close relationship with Creator and my spirit helpers, and they always pushed me. If I wanted to go another way, they're like, nope, and they kind of kicked me in the butt, and I was just like, okay. And I stand with Indigenous communities that don't want industry in their territories, and especially with Wet'suwet'en in 2019 with the interim injunction. That's when I kind of really did a lot of support work there, especially here in Toronto, mobilizing, organizing, and throughout my journey, I have made connections with other land defenders and organizers. So when 2020 happened, I was in my 4th year of theater school, and my auntie was sick out west, and on my winter break, I went to go visit because she had stage 4 cancer, and so I arrived at my dad's place there, and he got a phone call, and then he's like, CGL just got their permanent injunction. He's like, we're going to the Yinta tomorrow. And I was just like, oh shit. And I know what that meant. And so we had a meeting, we went out to the Yinta, and then that's when I had to make that quick decision to stay, to leave my life in Toronto, to leave my apartment, to leave school, to leave work, to leave my community. And also, like, yeah, the life that I knew. I wanted to be able to say at the end of this life to Creator that I did everything in my power that I could to protect my lands, my territory. At that time, my father had just gotten his name. He's a hereditary chief, Chief Was. So, yeah, I had to, I also had a partner at that time. And I also had to, I had to leave him. But he's Haudenosaunee from Six Nations, and actually he came with me. And so February, and yeah, we ended up kicking out CGL January 4th. And that was beautiful. Like luckily there was like just minimal because it was the holidays. And so we kicked out industry out of the territories, and it was beautiful. We shut down the roads, the access roads, and we lived off the land. That was like true sovereignty. We weren't just a government number. We weren't policed. We weren't told what to do, where to go, what to eat, anything like that. It was beautiful. And I tell you, like, you're out there in the elements, right? Like, you could die. I was a first aider, and I was like, I only have, like, basic training. If somebody were to get injured, we're looking like at impalement. We're looking at like animal, like, bites. Like, this is, like frostbite, what have you. But then after, it's just like, you're not scared. You know that the ancestors are there with you. You know that the animals know why you're there. And so February 7th happened. And that's when I was arrested. There was, 3-day military invasion. And, that day we had, like 100 militarized RCMP descend on us. It was just like, it was so surreal. It was like a movie. But, standing your ground, there is a part of you that, you don't want to move a certain way. I was holding a feather, and, I was going like this, and I was like yelling at the RCMP, and my partner was just like, Eve, don't. Like, they're going to think that's a weapon. They're going to think that's a gun, and you're going to get shot. And then I was just like, oh, like, I didn't even really think about that. And then, we ended up getting arrested, and, it was just, and we just found out we were pregnant. Actually, we had just found out 2 days before. And, that's something that you do not, obviously, I didn't go. I'm pregnant, I'm gonna go. No. But that's the reality of our people. Mothers do not have a choice. We face and we carry health issues, and we do not have a choice. We still have to do this work. We carry a lot on our shoulders, and that's why we ask for solidarity. That's why we ask when we say, come join us, come stand with us, because it's, bigger than us, right? This is the future generations, and that's exactly what I thought when I got arrested. And I had to put myself 20 years down the road and ask my daughter, would you have wanted me to stay, or would you have wanted me to go? And of course, knowing Cassia, that's her name, I named her after the territory, and she would have been like, I would have wanted you to stay, because it's our community, our people, generations upon generations of people impacted. The land's destroyed, the water's destroyed, our medicine, salmon, habitat, our communities, sex trafficking, drug trafficking is all impacted by industry. And so, we see Shut Down Canada. It was like wildfire. You see solidarity from all across Turtle Island stand in solidarity with us after Freda got raided and arrested our matriarchs that last day there. And we didn't know we were in jail, we were in the holding cell, and we didn't know what was going on in the outside world. And then, coming out and then seeing, everyone just shutting it down. The railroads, the ports, the borders, everything just shut down. And you want to know what? Canada, the government, did not want to sit with hereditary chiefs, the true title holders of those territories, which they did not get consent, which means that project is and still is illegal because they did not go through proper channels. And so the government would not sit down with hereditary leadership. But because of the solidarity, because of shutting it down, that's what brought ministers to the table to hereditary leadership. So that is the power of standing with us. And it wouldn't have happened if it wasn't for the outside support. It wasn't for people, it would have not have happened if it wasn't for people showing up. And so I really like to show that, because we all did that with just our spirit, our bodies, and our voice. And of course, people bringing their skills, and of course, being organized. But, so, I say that because, also, in Toronto and, Vancouver, Victoria, I saw these groups. They would throw down, but there was no communications between the groups. And sometimes they were doing action, on top of each other the next day, and people were getting burnt out. And I was like, if there was communications between the groups or strategy, that could have really drove it home. We could have really made it, we could have really shut it down. And this was all before COVID happened. And so when the bills came, okay, so fast forwarding to now, to the summer, seeing the bills, right? And I'm a land defender. I don't know anything about the bills, the legislations up until the summer, and so I'm just really learning fast. And then so that's where the 8th Fire Rising came out of in response to the bills. And I am also a financial divestment campaigner for Get 'em Done Checkpoint, so I pressure investors to divest from these projects like the Coastal GasLink pipeline, and also Phase 2 now, and also a lot of other industry. And so yeah, I started like contacting like everyone and being like, okay, this is where we need to connect. This is where we need to, okay, yeah. This is, and so we created like, yes, we have like about 20 Indigenous like movement leaders from impacted communities, and we have to like connect with other movements too, because all these bills, it's a strategy to just flood us. So now this is the time where we have to come together, because not one group or one nation is going to be able to fight it all. So that's where 8th Fire Rising came into being, to strategize, connect with each other, and also connect with our allies and other groups. And so join us, reach out to us, check us out. We have a website, and some folks are also a part of 8th Fire Rising, and we're always trying to build more coalition, more solidarity with each other. And especially if something happens on the front lines, we will respond to that. Okay, sorry.
I'm so sorry to cut off these voices, because, you know, I spend a lot of time wishing I was hearing a lot more of this in this building, as you can imagine. So I hate cutting you off. I should have known that all of you have so much experience that wouldn't have been enough time. And I wouldn't have cut it off if I didn't know that Neskantaga does have to get to the airport. So what I'm going to suggest right now is maybe we'll have our students close off the event. I have some gifts for our panel, and then we can do some more informal Q&A with however much time people have, if that works. You can go there or here, it's up to you.
Okay, thank you so much everyone for coming. Thank you so much to everyone on this panel for taking the time to be with us here today. I know I appreciate it, and I'm sure everyone else here is really grateful to hear from all of you. And thank you to everyone for being here. I hope you learned something or enjoyed yourself. Professor Scott is just bringing some gifts, but yeah, I just want to thank you all so much for being here today.
I have one more thing to say, just as I'm handing these out, which is that Wayne and I have worked together for a really long time, and it's taken me a long time to get to bring Wayne to the law school. Yours is actually in here, Wayne, which is a special one for so long working with us here. Yeah, special. Yes, you're welcome. Thanks everybody for coming. Well, actually, I had something else to say, which is that if they do get the CEO of Wailu up to the camp, they should just feed him that chicken soup porridge. Thank you, everybody, for coming. And I hope you bring your questions up to folks up here, okay?